Thank you for your patience. Good evening and welcome to the monthly meeting of the Board of Zoning Appeals, which is also known as the BZA. I'm Judy Freshman, Chairman of the Board. The Board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Intamalis, Paul Melnick, and Peter Owen. Also present is the professional staff, including Amanda Clement, who serves as Secretary to the Board of Zoning Appeals, Arlova Vaughn, Zoning Administrator, Cliff Nogan, Assistant to the Zoning Administrator, and Simon Keynes, Administrative Technician. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you will find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen that report for your case, that you get a copy and review it before your case is called. The Board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the County Board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the County Board. The Board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there's no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance. And we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the Board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the Board must determine that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting of the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, that the hardship is not generally shared by other properties in the same zoning district, and that the authorization of the variance will not be of substantial detriment to adjacent property, and the character of the district will not be changed by the granting of the variance. A Virginia Supreme Court ruling requires that a variance cannot be granted unless the effect of the zoning ordinance as applied to the piece of property under consideration would, in the absence of a variance, interfere with all reasonably beneficial uses of the property taken as a whole. When deciding appeals of the zoning administrator, the Board must determine if the administrator acted correctly. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, Board members will ask any questions of the staff they may have. Next, applicants or their representative will be given the opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so the comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the Board may permit the applicant a brief opportunity to clarify any points. The Board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances. For use permits, variances, and appeals, we've deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the Circuit Court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
V-11221-17-UP-1 is a use permit request to permit a setback of 7.6 feet to the wall from the left side property line instead of 10 feet as required, and an aggregate yard width of 16 feet instead of 18 feet as required. This is for a new rear addition on premises known as 1838 North Columbus Street. The staff recommendation is to adopt the resolution granting the subject use permit with conditions.
Any questions for the staff? Mr. Melnick.
So I noticed in the survey, in the staff report, it mentions 7.6 feet to the wall, but in the surveys, it only seems to mention 7.7 feet. And I didn't know, if that measurement is just not on there. But I was looking, I wanted to make sure, about the measurement. Is it actually 7.6 that is being requested?
Oh, yeah, 7.7.
I would defer to the applicant on this. I think it was advertised at 7.6, which would benefit them. That might have been an error if they were requesting 7.7.
Because do you see what I was looking at, the proposed addition? Do you think somebody would have marked on there the measurement? But okay, we can, maybe the applicant can clarify that.
Can we hear from the applicant, please?
My name is Jacob Weaver. I'm an architect for the applicant. I was just here to answer any questions. The 7.7 is to the face of the existing building and it's taken from the original, or the plat that we were furnished. So that 7.7 number is an existing dimension to the face of the building.
Okay.
And we are not extending beyond the face.
Okay.
Any other questions for the applicant's architect?
Madam Chair.
Yes. In addition to the architect. Sid Rahar?
I'm Sid Rahai, and I'm representing the owner and basically start building an addition. So I just want to make sure if you have any questions, I'm here to answer, but everything I believe already explained.
Okay. Any questions for the speaker? Thank you. Mr. Smith.
Madam Chair, I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11221-17 UP1, subject to the conditions that are listed in the staff resolution.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Aye.
Thank you. Next case.
V-11238-17-VA-1 is a variance request by Douglas Marshall to permit a main building footprint of 35.7% and a total lot coverage of 47.9%. This is for a new two-story addition with an attached garage, and this is on premises known as 6100 31st Street North. The staff recommendation is to adopt the attached resolution denying the variance request.
Questions for staff? Mr. Lawson.
Thank you, Madam Chairman, members of the board. My name is William B. Lawson, Jr. I represent the applicant. First, want to address the use permit and the prior variance. Apparently, there was confusion way back when this was granted. And according to the applicant, the porch was always meant to be enclosed. And Scott McGarry made the standard motion, and nobody caught it until later. The porch drawings do show it enclosed, and it was constructed, and it was approved, and so forth. So this is kind of a cleanup. On the proposed new addition, the staff acknowledges that some relief is probably appropriate, but they recommend denial because of the coverage situation. The setback of the addition is further away from the street than the current house, and we're in a little bit of a catch-22 because if we do move it further back to not have a problem with a use permit, then we add to coverage. And so we thought probably we ought to leave it where it is. Again, we have a situation with a handicapped individual. And Doug has a handicap, and it's going to get worse as his life progresses. And he wants to move his elderly mother into the house. And she has her mobility is also impaired. While this proposal exceeds the allowed coverage, again, we don't think the total footprint of what we're doing is really any more than some of the 2.5 and 3-story McMansions that are being built all over this neighborhood. This neighborhood is mostly 1-story ramblers, and it looked like just about every other lot in this neighborhood has been replaced by a very tall, substantial, huge house. I want to go over for a few minutes on the variance, the staff's reasoning in recommending the denial. And as I get into that, I want to say again, Ms. Freshman, Cochran was legislatively overturned by the General Assembly. And, you know, Cochran did say all beneficial use has to be precluded. And the General Assembly did not like that, and they legislatively overturned Cochran. So Cochran, in my opinion, is no longer good law. On their first staff analysis, and this is on page 3, number 1, it says, you know, the entire reason for these improvements is to create one-floor living. And as I've learned about aging in place and designing for handicap and so forth, you want one-level living. The staff is basically saying, well, you shouldn't get the variance because you can build up like everybody else is, and therefore you shouldn't get the variance. And I think that a reasonable use is being precluded, and I think the staff is unreasonable in demanding a 2-story solution just to comply with an arbitrary coverage. On the next one, number 2, this is the physical condition relating to the property or improvements thereon. The staff talks about, you know, there's nothing unique about this property, but they did not address the fact that what causes the hardship here is the current improvements thereon. And we have 2 problems. One is we have an existing pagoda, and this is 4 columns with a roof, and yet that is counted towards the coverage, and it's 4% of our lot, which has really impacted it. And then the second is we have a detached garage, which we lose, and that causes a double whammy. We lost 5% of our coverage bonus because it's a detached garage. Then we have to turn around and add the garage into the coverage of the main building. So it's kind of a double whammy that we get hit with. All we're really doing is filling in the gap between the house and the garage with the new addition. And that's about 380 square feet, and that's really all we're adding. But because of the way the ordinance is set up, it looks like a dramatic increase. As far as the next page, on page 4, talking about the increase in impervious area, the way that this is done, any impact would be straight to the street. There is no impact on any abutting neighbors. I'm almost finished. I went over with Doug some alterations that we could make, and I have 2 documents that I can hand out, and we've come up with 4 ways that we can reduce our coverage. We don't get in compliance with the ordinance, but I wanted to share with you all my list, and I wanted to share with you all the plat that shows where these alterations can be made. And I'll go ahead and hand these out.
Can you sum up, please?
That's it.
Thank you. Questions for Mr. Lawson? Ms. Malice? No. No questions? Mr. Melnick?
I have a question for staff.
Good evening. So you were mentioning that this is 1-story living, but I was trying to understand because I didn't see like at least an elevation that appeared to be the current elevation, but the addition looks like it's 2-story, but when you were saying 1-story, is that just adding on top of the garage, or?
Yeah, what's happening is we're coming into it's kind of slopes down as you go around. So he's coming into the garage, and he wants to be able to enter the house. He'll be going lower, and so he'll enter the house, and he'll have a little mud area, and then they're going to have a stairway and an elevator. And then the 95% of the living will be done on one level above the garage, and above the area where you come up to the second floor.
Okay.
That help?
Yeah, it does. Thanks.
Any other questions?
Yes.
Mr. Owen?
I guess I'll start with staff and then also give the applicant a chance to address it as well. Right now, we're talking about the variance request. I will have some questions when we get to the use permit request about the porch on 31st Street. What I'm wondering is does it matter whether the porch is enclosed or unenclosed? Or let me start with the applicant. Is your client planning to build over the enclosed porch on 31st? Okay. So whether or not that use permit is granted should not affect any of the calculations that are included in this variance. Is that right?
No, it should not, because the area of the porch has already been considered as it is existing.
And so even if it were needed to be made unenclosed again, the exact same criteria would be applied to the variance as far as you're concerned? Mr. Lawson, is that also your understanding as well, that the variance is unaffected by whether the porch is enclosed or unenclosed?
Yes, sir. Back when Margie was doing what Amanda's now doing, whenever there were porches, she would put on, you can't go above it and you can't enclose it. And what was, I guess it just wasn't clear according to Doug at the hearing. He always intended to enclose it. And when I look back at the drawings, it's just not clear. And so that standard motion got made and got adopted. And this would just clean up the situation.
Well, we'll have a chance to address that in more detail when we get to the next item.
Okay.
Thank you.
But we do have the 1997 report that it does say condition 2, the porch shall not be enclosed or built over.
Right, I saw that. But
Point of fact.
he just missed it, I guess.
It's a major issue, though, now. Yeah. Okay, any other questions for Mr. Lawson or staff?
Madam Chair, one question.
Mr. Smith?
The elimination of the pergola, you said gets you 4%, you said?
Yeah, it doesn't help with the main building footprint, but as far as the overall coverage, it'll pretty much put us right at where we need to be. Within, looks like within 2% or so.
Right.
Yeah, we would be within 2% of overall, but the problem that he has, or what's more a dramatic variance, I guess, so to speak, is the main footprint. And that comes about because now the garage is added to it.
Right.
Okay. Questions? Comments?
Not for Mr. Lawson, but for you.
Go ahead. Ms. Malice.
You know, the notion of one floor living being a justification for exceeding lot coverage or building size, I feel is a policy decision because every home in Arlington could make that argument that they need to exceed. And we don't have any criteria or justification in order to act on that. I mean, that's something that legislatively could be discussed, but basically that's an argument that every homeowner could make, is that they want to expand their footprint because they prefer one floor living. So that's an argument I think is for someone else to adjudicate at some other point in the future. I'm still not, so I'm not seeing the unique hardships here in terms of the coverage.
Thank you. Any other comments or questions?
Well, let me ask the applicant if, is it possible that this could be reconfigured if we gave you more time to...
Are you all discussing right now the variance?
Yeah.
Yes, only the variance.
Both at the same time. I apologize.
No worries. You can come back.
One of the things that we looked at, Mr. Smith, is we have a phone pole, and I have a picture I can show you, right where the driveway is. And one of the things I had thought about is shifting it this way. Oh, there's a picture right there. You see that there's a guy wire that comes down off that phone pole that gets pretty close to that driveway. And it's an expensive thing to contemplate, reorienting that pole or doing the guy wire or something, but we might be able to adjust it some.
I have a question, Madam Chair.
Mr. Milner.
So when you mentioned the elevator, it seems to me with an elevator, though, then the one floor living, you can do more flexible, as far as movement, with floors. And had the applicant considered, as the staff was recommending, just going up, to avoid, at least maybe a large share of the coverage, utilizing an elevator?
I don't think you want to do that. Is that? I mean, can you do that if you wanted to, or can you even do it? That's really something that he says it just won't lay out right if he does that. So, but I have not looked at that myself personally, but I know that that's not what he would like to do.
Okay. Thanks.
I think one point to expand on that is just that it might be one thing if we were suggesting a second floor that required an elevator. If an elevator is already in the plan, then there's logic to that suggestion.
Yeah, but it's very different to drive in and go up in the elevator versus going up and down all day long. And so also one of the things that Doug wants to do is have this so that it's an accessory dwelling unit. And we expect that the law will get changed on that soon. And so he would have a situation where he has his area, and then he would have an accessory dwelling unit in the new area that he's proposing to add. So then it wouldn't work for that if we did the second story in the elevator.
Any other comments or questions? What is your pleasure?
If the applicant had alternative designs that he wished to bring forward that were within the coverage guidelines, I would be interested in seeing those, but that would be at another time in another place.
Yeah, we would, if it sounds like you all aren't inclined to grant it, if I could have a 2-month deferral, we'd like to look at the ability to shift it, if that's okay.
Yeah, I think it'd be very helpful.
Okay.
Let's have a motion.
Madam Chair,
Ms. Malice.
in case number V11238-17-VA-1, I move that the Board of Zoning Appeals defer this item to its May 2017 hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Smith for a 2-month deferral to May. All those in favor? Aye.
Thank you.
Thank you.
Mr. Lawson,
What about the next item?
don't go too far. Got another item.
No.
Staff, please. Next item.
V-11238-17-UP-1 is a use permit request to permit a setback of 23.2 feet to the wall from the North Ohio Street right-of-way instead of 25 feet as required, and to modify a previous variance approval that permitted a setback of 16 feet to the North 31st Street right-of-way and 10.8 feet to the North Ohio Street right-of-way for a front porch. This is on premises known as 6100 31st Street North. The staff recommendation is to adopt the attached resolution granting the use permit to modify a previous variance approval that permitted the setback of 16 feet to the North 31st Street right-of-way and 10.8 feet to the North Ohio Street right-of-way for the front porch, but denying the request to permit a setback of 23.2 feet to the wall from the North Ohio Street right-of-way.
Thank you. Mr. Lawson.
Yes, ma'am. I already made the presentation. I would just add a couple things. One is we have a statement of support from the Williamsburg Civic Association from 1997. And Doug tells me that when he made the presentation, he did indicate that it was going to be an enclosed porch. And I'll hand that out for your all's consideration. That's it.
Given that the variance has been deferred,
Well, I think the one use permit should be deferred. I think I would ask you to clean up the porch if you don't mind.
Madam Chair,
Mr. Owen.
I have some questions.
Yeah.
Mr. Lawson, are the windows that we see here in this photograph in front of the porch, are those all glass?
They are, correct? Yes.
All right, so I have a question for staff. What's the difference between an enclosed front porch and just a front room? How is this a porch and not just an integral part of the house?
Well, the difference is the enclosure, and so this, well, so by definition under the zoning ordinance, a porch is unenclosed. This is an enclosed structure, so it would be considered the same as part of the main building.
Okay. I also note that you can see here in the photo that this structure has little porches on either side of it. It's sort of a porch on the porch. And I think part of my question that I'm wondering on this one, there's other applications tonight, there were some others at our last meeting, where I'm not sure that I fully understand where we're drawing the lines. So I think some have asserted, and maybe they're right, that Arlington County zoning has essentially a policy in favor of adding porches, that at least unenclosed, uncovered porches, that the zoning ordinance creates exceptions to allow those kinds of porches where they otherwise wouldn't be permitted. But what I've noticed in my first year here on the BZA is that sometimes we have an existing uncovered porch and someone asks for it to be covered. Someone has an existing covered porch and they ask for it to be screened. Someone has an existing screened porch and they ask for it to be fully enclosed. And each time the justification is, well, this is only a little bit, it's hardly different at all from what we have before. But what we wind up with is we started with an open uncovered porch, and through 4 separate actions, each of which is nothing at all, we wind up with something that becomes an integral part of the dwelling. And so it's not clear to me, based on the zoning ordinance and the policies and laws enacted by the county board, if there is supposed to be some sort of, where do we go from, where's the point at the beginning where it's favored, to the end point where if we weren't calling it a legacy porch, we wouldn't even be considering it potentially. So that's just a question in my mind. I'm going to favor a deferral on this action, but I wanted to let you know it's a question in my mind. Also, I do feel, and this is something I expressed to staff ahead of time, I did not see in this application the analysis we usually see for this kind of encroachment. So we're required under the ordinance to see if the footprint size and placement is similar to the structures on the property surrounding the subject property. And typically for this kind of encroachment, we would see in the staff report some kind of list of the other properties that are similar, and no such list appears on this occasion. And so it's probably good, Mr. Lawson, that you're asking for a deferral, because I think I would have had a tough time granting. I'm sorry, you're not asking for a deferral, you're asking for approval. I think I will have trouble doing that if you insist.
Yeah.
Myself, you might get 4 other votes, but I'm having trouble doing that without that staff analysis. On my own walkthrough in the neighborhood, I did see other enclosed structures that look sort of similar to this, but they were farther back from the street. I did see some unenclosed, I think mostly uncovered porches that were similar to this, but they weren't similar. They were not an integral part of the dwelling. So I myself, walking through the neighborhood briefly as I did, I couldn't immediately discern how this is compatible with the immediately surrounding neighborhood. And so without more information about that, I'm not sure that I would feel comfortable supporting it tonight.
Madam Chair? Yeah, just to follow up, so simply granting the setback assumes that approval of the enclosed porch. I mean, I was reading the text, and the text in the staff report just says that the board's acceptance of this modification, the right-of-way, would resolve this discrepancy.
Yeah,
That's a big step.
that's referring to the applicant's claim, and having been present before, that there was a discrepancy and that this was always supposed to be an enclosed porch.
But your report is suggesting that if we accept this setback, then we accept the porch.
That if you accept the modification to the previous approval for the porch. So there's 2 different requests under this use permit, the one for the setback for the addition on the rear, and then the one for the modification to the previously approved porch.
I see, okay, got it. And but it's very not really explicit. All that's saying is, it's not saying that we approve an enclosed porch. It's saying that we approve the permitted setback.
Well, 'cause
how you get from one to the next.
in other cases where, it's not really analogous, but it sort of is, that you have a situation where a house is non-conforming, and part of the action is to bring it into compliance. I see it as a similar situation, and I guess I'm just saying that if whatever action is taken ultimately on this use permit essentially means that a porch, which wasn't supposed to be enclosed but was, is now okay, I think it should say that. In the same way that other applications have a change of some sort that also includes bringing the whole place into compliance. I would rather have language when we get to that point that's explicit on just that point, apart from any other part that's been, anything else that's being requested, because then it's not just assumed and rolled into something because the language isn't clear at all about that.
Right.
Mr. Melnick.
Yeah, I noticed that too, and it seems to me that staff was trying to cover that point because it does mention the submitted drawings and plans. So I think that's where it was supposed to be covered. But I agree. If that's what we're doing, you might as well say it.
Madam Chair.
Mr. Smith.
And it looks like in the alternative resolution that's included in the packet for our consideration, it does say, they create the language, well, they just write the language enclosed front porch and deal with the setback, and that kind of blanket
Assumes
kind of corrects it without being explicit. Really, what it seems like it needs is another whereas that says, whereas the variance granted in 1997 was, misunderstood or was misunderstood to require an open porch, and the applicant unintentionally enclosed that porch, and now therefore be it resolved. Kind of a resolution that sets out that one fact that motivates the application.
Ms. Malice.
Just add to that, because the next sentence in that same paragraph is a finding. It says, additionally, it is found that the existing enclosed porch does not further increase the main building footprint, or lot coverage. I mean, we're doing a lot here without being explicit.
Okay. Any other comments or questions?
It's not clear to me, based on the evidence I see tonight, that the BZA in 1997 understood or would have predicted a new front addition based on their approval. So I don't see this as a technical matter. I see this as essentially a fresh question for the BZA as to whether or not this new front addition meets the criteria for a use permit.
Okay.
Madam Chair,
Mr. Smith.
follow up on that. I guess I'd want to hear from it. Well, I know that there wasn't like a notice of violation that's been issued all in the last 20 years with respect to this, right?
No.
So it came to light as a result of this new application for the addition on the rear.
That's correct.
Some astute planner saw that looks enclosed and looked at the variance application from 97, and there was kind of a discrepancy in their mind about whether that was permitted. Was a notice of violation then issued?
No.
Okay. All right. So if they were to withdraw the application for any changes to this property whatsoever, would, as Ms. Malice just added, I hate to say that kind of a thing because I don't want to invite a notice of violation, but would that flow?
Now that it's come to your attention.
Could, but the point, I mean, our enforcement process is always to obtain compliance, right? So we could, and the remedy would be to come here. Or
That would be one path.
yes, that would be, yes, one of.
Gotcha. Okay.
But the appropriately worded condition would end up, when the action is taken on the use permit, would end up addressing it.
And in general, our zoning enforcement is a complaint-driven process, right? So there have been no complaints, so you wouldn't be in any rush to issue a notice of violation here, right?
No.
Okay.
I don't want to cause paranoia at all, but I just wanted to kind of follow it to its logical conclusion.
Okay. Ready?
Madam Chair, I will make a motion for deferral. In the case V11238-17-UP-1, I move that the Board of Zoning Appeals defer this matter to the May 2017 hearing.
Second.
Moved by Ms. Malice, seconded by Mr. Smith for deferral for 2 months to the May BZA meeting. All those in favor? Aye.
Thank you.
Thank you. Next case, please.
B-11240-17-UP-1 is a use permit to permit a setback of 14.63 feet to the wall of the enclosed porch instead of 25 feet as required, 13.13 feet to the eave of the enclosed porch instead of 21 feet as required, and 14.03 feet to the bay window instead of 23.5 feet as required, and 17.93 feet to the base of the open porch instead of 21 feet as required, and 17.1 feet to the eave of the open porch instead of 19.5 feet as required, and 22.93 feet to the wall of the cantilevered second floor instead of 25 feet as required, and all from the 24th Street right-of-way. This is for an enclosed porch, a new open porch, and a second floor addition on premises known as 5618 24th Street North. The staff's recommendation is to adopt the attached resolution granting the use permit with conditions.
Thank you. Questions for the staff? Hear from the applicant, please.
Hi, I'm Josh Kaplowitz, and this is my wife, Andrea. We agree with the staff recommendation, and we're excited for the renovation and looking forward to hopefully getting started soon. I don't know if you have any questions for us.
Any questions for the applicants? Mr. Owen.
Did the house to your right recently get rebuilt, or do you know, was it on this photo, the one to the right of where your house is?
The white one? That was redone probably in the early aughts.
So about 10 years old?
Yeah, it happened several years before we moved in.
Okay. But it looks like that was a tear down and rebuild, right?
No, that was the original that was added to the back.
Okay, got it. Go ahead.
Mr. Melnick.
I'd like to make a motion.
Oh, actually.
You have more
Mr. Owen.
You have more questions, sorry. Just to put your mind at ease, I'm inclined to vote in favor of your stuff.
Thank you.
All right, but I have some other questions I want to ask staff, so I don't want to freak you out. So once again, this is one where I'm questioning the definitions used, right? So we're talking about an enclosed front porch, and we're not talking about a front addition or new front addition, and I'm not sure I understand the distinction between those two terms. And this is another situation where we have a porch that, in this case, it's at its final iteration before becoming an integral part of the dwelling. The applicants acknowledge that that's their goal, and then they're building, like the last one, there's going to be a porch on the porch, right? And so, perhaps the process would start again. In this case, I think, unlike potentially the last one, the compatibility issue is not as much of a concern for me. But I am a little bit concerned for this with how the staff justifies it. So what I see here is this application, and granted, there's the easements and so forth that are present in this case that make it a little different. But looking at all of the examples that the staff have listed, they're all less than 2 feet, 2 or 3 feet from the minimum 25-foot required setback, whereas this one is about 10 feet closer to the street, substantially closer to the street than any of the other, supposedly precedent-setting examples. And I'm, again, wondering, and this is carrying over from a question I had at the last meeting, is any encroachment a precedent for any other encroachment, irrespective of the distance? Is that sort of the mentality, or do we care if this is the closest one ever so far? And I just, because what I worry about is ultimately that we get into some kind of lowest bidder kind of situation where each neighborhood, someone's finally, doing more and reaching out with the new front porch and then enclosing it and getting closer, and everything that ever broke the rules ever before is all considered a precedent for anything else. And I'm just wondering, are there further dividing lines besides just the, someone crossed the 25-foot limit? So in this particular case, I think given the placement of this house, given what the next door houses look like, given the nature of the easement, and given the fact that, in fact, I think your new proposed true porch that you're now proposing doesn't seem to encroach much or at all farther than the existing structure does. So it's sort of rounding it out, but not pushing it closer to the street. You know, I'm not necessarily as troubled, but I just, in general, I'm wondering if this is the right analysis that we should be using. So I don't know if staff has any comments today on that, but I thought I would get it off my chest since this is such a good example of the phenomenon.
So I think this is a good example of where we consider things case by case and not necessarily just based on if there's something that's already encroaching. And so in this case, we're dealing with an already enclosed porch, a porch that has already been enclosed, that is closer than the other examples that we've provided. However, the enclosure of that porch was by right due to a provision in the ordinance that allowed any porch that existed prior to a date in 1976 to be enclosed. And so in a case like this where we already have the porches being enclosed, really the use permit in this regard is needed to provide for the modifications and the alterations to update this existing enclosed porch, which appears compatible with the other renovations that they're doing. So I think that was taken into account when considering the staff's recommendation to approve this one.
Thank you.
Well, and to put your mind even further at ease, the sidewalk easement is actually a bit ironic because they're actually going to be building a sidewalk into the street, so it'll be actually visually even further from the actual street. And I should add that picture doesn't reflect that there have been a couple other tear downs since that picture was taken. So
maybe that's what I was reacting to, because it didn't look quite like what I remember seeing this weekend.
Yeah, no, at the corner there are two massive houses, and then two down on the left was another tear down. So we're just continuing that trend, but building on top of what's already
Not as bad as they are.
Exactly.
We're keeping the same footprint.
Yeah, I think it's a good point.
Doesn't sound flattering.
Well, that is
Better purview.
it's a recurring problem with Google Maps, though, is that they're hopelessly out of date.
Yeah.
Any other comments, questions, the applicant? Motion?
I'll make a motion.
Mr. Melnick.
All right. So in case V 1124017 UP1, I'd make a motion that the BZA grant the use permit with the conditions as stated.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith. All those in favor? Aye. Thank you.
Thank you very much.
Enjoy.
Yep.
Next case, please.
V-11069-15-UP-3 is a use permit request to permit a setback of 0 feet to the stairs from the 23rd Street South right-of-way instead of 5 feet as required, and 13 feet to the landings, 15 feet to the eave, and 17 feet to the porch base from the 23rd Street South right-of-way instead of 21 feet as required, and a setback of 15.6 feet to the sunroom from the rear property line instead of 25 feet as required, and 14.3 feet to the eave instead of 21 feet as required from the rear property line. This is for a new front porch with landings and a front stairway and a new rear sunroom and roof patio. This is on premises known as 5017 23rd Street South, and the staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions for staff? Hear from the applicant, please.
Hello, my name is Matthew Geis with Reform LLC. We're the architect representing the homeowner. This was previously a previously approved application back on May 11th, where we had about a 310 square foot addition off to the left side of the house. And due to budget constraints, that addition was eliminated. So in essence, this revised application maintains all of the existing elements in the front, except the porch no longer carries across the addition, as that's no longer there, and to compensate for some of the square footage in the interior, rather than generating the addition, will be or renovating the existing enclosed sunroom to the back within the same existing footprint.
Questions? Thank you.
Ready to make a motion?
Mr. Owen.
Madam Chair, I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11069-15-UP-3, subject to the conditions listed in the resolution.
Second.
Moved by Mr. Owen, seconded by Ms. Malice. All those in favor? Aye. Thank you.
Thank you.
Next case, please.
V-11241-17-UP-1 is a use permit request to permit a setback of 10.7 feet to the wall from the left side property line instead of 16 feet as required, and 10.5 feet to the eave instead of 12 feet as required. This is for structural alterations to an existing non-conforming porch and garage. This is in the R10 zoning district and on premises known as 3438 North Emerson Street. The staff recommendation is to adopt the attached resolution granting the use permit request with conditions.
Questions for the staff? Applicant, please.
My name is Shamal Chowdhury. I'm with Moore Architects PC, representing the owner, and to answer any questions the board may have.
Thank you. Any questions for the applicant's agent? Hearing none.
Madam Chair,
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11241-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice. All those in favor? Aye. Thank you. Next case, please.
V-11099-16-VA-2 is a variance request to permit a setback of 2.7 feet to the porch, 9.5 feet to the eave, and 9.6 feet to the existing home and half-story addition from the North Culpeper Street right-of-way instead of 25 feet as required, 8 feet to the 1.5-story right-side addition from the right-side property line instead of 10 feet as required, and 1.7 feet to the eaves and 3.7 feet to the existing home, the half-story addition, and the existing porch, and 2.9 feet to the eave and 4.9 feet to the 1.5-story rear addition from the left side property line instead of 8 feet as required, and an aggregate side yard of 9.7 feet instead of 16 feet as required. This is on premises known as 2116 North Culpeper Street, and the staff's recommendation is to adopt the attached resolution denying the variance request.
Questions for the staff? Hear from the applicant, please.
Good evening, ladies and gentlemen, board members. I'd like to introduce myself. I'm Elena Keith. I'm the owner of the property, 2116 North Culpeper Street. And I'm here a second time following the approved variance from February last year, February 2016. And first of all, I'd like to provide everyone additional signatures of support and additional information on the property, if I may.
Thank you. Yes.
Overall, I've collected over 500 signatures in support of this project from the neighbors, community, and from those who visit Heidelberg Bakery and the community center next to the house, across from the house. And I'm here also to apologize for several things. Just let's give a little bit of a story that associated with this house. This house was purchased in July of 2014, and immediately after the house was purchased, a large tree fell on top of the roof and damaged the property, severely damaged the property. It took me over a year to collect all necessary documents, take necessary steps such as securing financing to rebuild the property, getting architectural plans in order, and securing building permits. And I had to go through several stages of building a house. The first time I had a contractor who I had to let go because he was not performing well and his licensing wasn't proper. I've got a second contractor, and they're great guys, and one of agents of the company, Mr. Norman Pardo, is right here, and he'll be speaking on about this project. What happened, this house was approved as a rehabilitation project where the walls were supposed to remain. That was the condition of the previous variance that we were granted in February 2016. And everything was going fine till they've exposed the lumber, the original studs within the walls, and the underlayment and steel plate that is a part of the foundation wall. And it turned out that it was severely rotten and affected by termites. And then the guys evidently took the walls at the same time without, basically, they've explained to me there was no other way, and that caused all this situation. So basically, this was not predictable. I would say it was not expected. I did not anticipate it, and it was also shocking for me. And I'm here to apologize for this situation, and I hope we would be able to rectify it somehow. This house could be situated only how it is situated right now, considering the design of the property. There are stairs in the back, exterior stairs that bring you to the second property, to the second story of the house. And it means I cannot...
Just wind up, please.
Sure. And those exterior stairs, they cannot be situated anywhere else in order for them to be covered. I have all elderly parents, and for them to climb the stairs, they really, that was their wish. They wanted to have cover over the stairs, and really, if we somehow twist them, it just would not allow us to comply with the necessary setbacks. And then, additionally, to move this house anywhere else would require a tremendous amount of funds. It would not be feasible, it would not be possible for a family to do that. Basically, the family would be homeless if we start moving the house around a lot. I will do everything in my power to make sure that the construction crew would be complying with everything that needs to be compliant. We will have inspectors on site as much as we can, but I do ask for your help to be able to continue working on this house. There is original lumber that was taken down from the walls, and the contractor would like to place it back because of that was the condition. We needed to keep the original lumber. As he explained to me, he could not do it while the walls were up. He had to take the walls down, but the lumber is still intact and could be placed where it was before. The foundation walls are constructed, and they passed all the necessary inspections.
Thank you very much. Let's see where we go.
you.
Questions for the applicant? Okay. We have 4 speakers. Let's start with Norman so that he can follow up on applicant's comments.
Good evening. My name is Norman Pardo, and I'm the contractor for Mrs. Keith. Whatever she was explaining is according to the agreement with her too, is to preserve the peripheral walls of the existing house. But unfortunately, when we took the siding, we found out that the sill plates, some of the joists, and the plates for the framing from the wall will all rotten, infested because of termites. And there was no other alternative that redo the whole flooring, taking the sill plate, and the sill plate, according to codes, we have to put anchor bolts, and the house didn't have none of them. All around the house was sill plates was totally rotten. So I had no other alternative that built new walls and put a new floor as well.
Okay. Any questions? Thank you. Stephanie Derrick.
Good evening, ladies and gentlemen. My name is Stephanie Derrick, and I live with my husband at 2022 North Culpeper. It's the townhouses located to the left of the property. And I've been a witness to most of the events that have occurred to this property in the last 2 years. First, I'd like to thank you for the opportunity to speak, and I'm encouraged by the board's recommendation to deny the variance request. We support this recommendation to deny, and again, thank you for making copies of all the materials that you have. I'm not sure there's anything else I can add in words that's not evidenced by the numerous documents, complaints, and legal issues that surround this project. I'm but one person, but I represent the frustration and dismay of many, some of whose letters are included, who could not attend tonight. This situation has permeated our entire community, and people are frustrated for a variety of reasons, but most of all because many of them have gone through the building process with respect for the rules and with a concern for safety of their workers and of the community, as it should be. According to the March edition of the Arlington magazine, which is ironic, it's no secret that there are challenges to this process, but it can be done, and it can be done safely in accordance to the rules. We've compiled a considerable amount of documentation for your consideration, and I ask that you also please speak to the building department, the public officials, including members of the county board, the ombudsman, the Arlington County Police Department, the Fairfax Police Department, and the Commonwealth Attorney for their experiences with this property and its owner. I also hope that if you have not, that you will visit this site, and if not, you will see that there are already safety concerns for yourselves, including the sidewalk, which has been mentioned at numerous meetings, and also noting that the walls that were put up are not to code, even if you were going to rebuild your house. So it's my opinion, that Mrs. Keith believes rules do not apply to her. It appears she has made her intentions glaringly clear when she raised her house. She wants to build a new house. She can do that, and she can follow all the rules everyone else does without a variance. Just one more sentence. She has not earned your trust and ours, and that she will not adhere to the safe building standards and therefore a variance to those rules. Again, thank you for your consideration. I'm available for any requests for the materials that I've submitted as well.
Thank you. Jim Derrick.
Sure.
Go ahead.
If I could ask a question of the immediate past speaker. Ma'am? It's okay. I was a little slow on the draw.
I know.
I think Ms. Malice also has a question. She's senior to me, so I'll let her go first.
What do you mean by that?
She's in service on the BZA.
Seniority on the board.
Children.
Ahead of me on the BZA.
Ms. Malice.
I don't want to put you on the spot because you may not have thought about this, but what would you like to see happen on this site?
Originally, honestly, we had thought we did want the property renovated. I mean, it's been a blight in our neighborhood for a long time, and we had hoped that someone would buy the property and they would build a house. We always had wanted the variance to be a lot further back to respect the 25 feet because we have a significant safety issue with the Heidelberg and her property's connection with that sidewalk. If the house is allowed to be built in the original variance, which was approved at 2.7 feet, then any curb, utility, sidewalk, any infrastructure, it's the only non-conforming property on the west side of Culpeper. So we would like that to be done. Considering the things that have been done now, we hope it just all goes away.
Well, it's not, there's a piece of property there. So one of the items on your wish list would be is that the house is moved further back since it's not new construction now.
If it's a new construction, then it should respect the rules of new construction and be built 25 feet.
Thank you.
Thank you.
Mr. Owen?
So my question for the speaker. Yeah. So I was not yet a member of the Board of Zoning Appeals in February of last year.
Yes.
And so I did listen to the tape and I heard some questions about the sidewalk. But when I visited the site, I did not take care to look exactly for what people might have been talking about. So could you take just a moment to describe with just a tiny bit more detail what is the sidewalk condition that concerns you?
Yeah, if you look in section F, there's actually, I took pictures of it, but essentially if you're walking down the Heidelberg sidewalk, you run into a fence, in which means you must make a left turn, you have to go out into the street, and then make a right turn to get back onto the sidewalk. And same way, if you're walking north on Culpeper, it just dumps you out onto the street. So if I walked straight into Culpeper, for example, I'd walk right into that black car. I would just keep walking into that car. So, when it gets really busy, Heidelberg gets very busy on the weekends, and it's right across from the community center. We have a lot of pedestrian traffic. So it's been a chronic issue, for strollers, wheelchairs, elderly people, just trying to navigate that area and making that, at some point, there has to be a connection with that sidewalk. Those two need to meet.
I appreciate the clarification.
Jim Derrick.
Good evening, ladies and gentlemen. I appreciate the opportunity to address the board about this matter. Just as with the last variance, which was granted by the BZA on February 17, 2016, we do not agree with the provisions of this new variance and request the BZA to confirm its denial. If the owner would like to build a house on a property, she should be subject to the code standards for new construction. It was her intentional actions to tear down her home and dig out the basement, both of which violate her variance. She has proven to be blatant in her actions, to not adhere to any building code, process, or rule which governs safe and sound construction. If she is granted a variance again, she will violate it, so let her build to the standards required of all new construction. Over the past year, her numerous infractions have reported to the county, have resulted in multiple stop work orders and citations, and are being addressed through the legal process. We still believe the conditions exist to deny her based on the BZA standards. She showed a lack of good faith in her application. There are many egregious errors in her application. She purchased the home using a form of the Heidelberg name, which is the neighboring business, the bakery, to draw an association that does not exist. She also states that the home was damaged by a tree which fell in a storm, which I witnessed as not true and is now under investigation with the insurer who paid her claim. As well in the original application, in the second request, she has misleading signed statement support from her neighbors. When you review these statements, you will find that the majority are not from adjacent property owners, or the majority of which not even living in Highview Park. With regards to public safety, I will restate that the front setback of 2.7 feet is detrimental to the neighborhood. You've seen the photos, the unconnected sidewalk. And in the future, for sidewalk, curb, drainage, utilities, it's a contraindication to elements in the master plan and NCAC standards. Hardship, and I'd like to finish with this. The owner has created her own hardship by not conducting due diligence on the property on the initial purchase and then by blatant construction actions. We are a property rights state, but there is a burden for people to do their homework. Ladies and gentlemen, many of our neighbors or people that are interested in living in our neighborhood drive up and down the streets on a daily basis. They stop, they take pictures because they're looking for opportunities. Why wouldn't they? So it would seem to me that people that are smarter than me and smarter than many people here that do this for a living would know better by looking at the property that there's going to be a lot of hurdles and challenges. So hardship is a real stretch, if you ask me. If I was going to spend this kind of money, I would make sure I had a really smart person who knew the law to do the homework before I put the money out. Thank you very much for your time.
Questions for Mr. Derrick before he leaves? Okay, thank you.
Thank you.
The last speaker is Tracy Greiner.
Can we go back to the first picture? My name is Tracy Greiner. I reside at 2117 North Cameron Street.
Is this the one you want?
Pardon?
Is this the
Thank you. I am the resident manager of 2117. I have been for the last 27 years.
Is that on the picture here?
Yes. I would like to point out that the red dotted line is incorrect. She does not own that whole parcel. That rear parcel of 1,100 square feet has been used as a dumping ground for over 2,500 square feet of dirt that she has excavated out of the property. There is a storm drain in the back corner of that property that she cemented over.
On the left side?
Yes. She is currently seeking buyers. She has contacted Ann Tonks, who owns 2110 North Culpeper, the apartment buildings next door, asking her to purchase the property. I'd like to go back to the original engineer report that stated the foundation needed $200,000 worth of work to support the original structure, and now she wants to build a new home on that structure when it couldn't originally even support the original one. She has done things like vandalized her own property, called the police, directed them in my direction saying I'm vandalizing the property. I have security cameras proving otherwise. Workers using behind the plywood shed as a bathroom. Just goes on and on. She has a vagrant disregard for any county process. We have been asked by building services, zoning, code enforcement to give her time. She has been given time and time again. My understanding of the first contractor on the building permit had no knowledge of his contract license being used by her. And that is why the first building permit was canceled out, and she was given a second one with another builder who was withdrawn from her thing. And the second building permit clearly stated she couldn't dig out underneath the existing structure, which a week later kept doing. The wood for the new construction was purchased and delivered before she applied for this second variance request. They knew then they were tearing the house down before they took the roof off and before they gutted the inside.
Okay.
No regard.
Thank you.
Could you point out who you're representing? You can go back to
I live at 2117 North Cameron Street.
That on
The
the picture
apartment
here?
building's directly behind this property. I've been there 27
Behind
years.
behind
Andy Brown building?
Yes.
behind Heidelberg.
Cars in the parking lot.
Okay. Thank you.
Thank you.
Thank you. Any other questions or comments? Questions of staff?
So, Madam Chair, my
Ms. Malice.
understanding is that the circumstances have changed now. The fact that there's a tear down engages different rules, and that's what staff is reacting to at this point.
That's correct. We feel that there are different circumstances as opposed to the first time this came through in February, and because of those changes, we're recommending a different action.
We have, since I've been on the BZA, have had situations where I can think of at least one where a house on a non-conforming lot was torn down by the owner or contractor somewhat unknowingly. And we did not permit them to rebuild as they had. We, in fact, had them go through a process of starting from scratch. And in other words, and I understand the extreme hardship this causes, but it's caused other applicants before this extreme hardship where unwittingly, not
fully understanding what the situation was. Because the walls were bad, very, very similar situations. We were not able to simply overlook that fact when we were presented the case. And I feel like that's what we're faced with here, is that we do have a set of different circumstances here that makes that previous approval moot.
Madam Chair.
Mr. Smith.
And just to kind of clarify, the by right option would be that, A, this is an R6 zoned parcel, correct?
No, it's been upzoned.
I thought it was...
RA 8-18.
Okay. That's a little different. Was that 10 feet on one side, 8 on the other, 25?
Yeah.
Single family on a multifamily lot?
That the setbacks are correct, yes.
And so that would be permitted by right?
On this lot, there isn't a by right option for new development because of the substandard size of the lot.
That's right. It's only 50 feet and it has to be 60?
It needs to be 60 feet wide and at least 6,000 square feet.
Okay. All right.
But all of the constraints of the site have been there, or were known at the time. Right. Mr. Melnick.
So it was hard to glean exactly, what the staff would prefer, but, because nothing's really by right. But so the staff's position is that what's happening here with this new building is just too extreme. Like, it's too close to the street. It's, all the arguments about, where it was as far as being kind of on one side of the lot and close. But does the staff, what are the parameters the staff could go with? Either, has that been discussed with the applicant?
No, we haven't had those discussions. We do recognize that there isn't anything that can be achieved here by right. And so we do recognize that a variance may be appropriate with this, but we do feel like a lesser variance could be granted and still make reasonable use of the property. And we would be willing to work with the applicant to find something more suitable for our recommendation.
Okay, thanks.
So, Madam Chair, just to follow up. So a 22-foot wide structure could be built. It's 50-foot wide lot. 10 and 8 is subtracting 18 from that. So actually it's 32. 32-foot wide structure could be built, which is plenty wide.
And setback.
And then there's certainly enough for 25 and 25 on the front and the back.
Madam Chair?
Yes, Mrs. Malice.
I also have a question about one of the speakers' assertion that this plat, the red line here exceeds the property.
Yeah, and that may be the red line on these locational maps. Just a highlight, not intended to really show the property boundaries. I would defer to the survey and the package.
I think the opportunity, though, if we are in fact, if the building has been torn down, then you have the opportunity, even if you grant a variance, to adhere to some of the requirements on not the least of which, from my point of view, is backing it up, because that whole sidewalk issue is I've walked that. It's unacceptable, and it was a situation where previously, if the house was going to be rebuilt, it was unfortunate and inconvenient, but now it need not be the case.
On some of that, there are issues with respect to, Madam Chair, if I might, there are issues with respect to building the back because there's a 10-foot storm sewer easement that kind of cuts across diagonally the property to the rear. Yet there is still.
It would still be. I mean,
still, I think you have to be. I think you have to be 10 feet from that easement, so you could still get something back in there. I bet.
But I think my point is not to replan it here,
Right.
but that there are replanting options, it will necessarily require a variance because there are no by right options. But that's doable. And this, application is not.
Madam Chair,
Mr. Owen.
I have a question for staff. This parcel, as we just discussed, it was rezoned from R6 to RA 818. Presumably, that was a policy decision by the county board to encourage a different kind of development here than single-family housing. And so my question is, in addition to a single-family home through a variance, what are the other development options that are more consistent with the county board's general plan for RA 818 with this GLUP category?
I think due to the existing size, I don't think that there are any other options for development because it is substandard. The other options, I think, would be to combine at some point with adjoining parcels to create a larger lot for development.
So if it were consolidated with any of its three neighbors, any one of its three neighbors, then potentially they might have additional development rights from the additional land area. Is that right? Or they could even build on this lot, combining it with whatever they're doing elsewhere. Those are additional development possibilities. And those would occur through site plan, is that right? Mm-hmm. Are there by right RA 818 options for multifamily housing for commercial buildings?
Multifamily, yes. Townhouses in some cases. For commercial, it looks like mostly via use permit for office and a few other types of uses.
So at some point, we may have to grant a variance to give this parcel its own individual by right option, but the highest and best use might be different than what we would grant a variance for. All right, thank you.
Thank you. Yes, ma'am.
I'd like to add, yeah, that's correct. The red line has to be moved 1/4 or more towards the house. So basically, that creates a better picture than moving house to the back. Even moving it a couple of feet, we would still not be ever compliant with the 25 foot to the front, to the back, 25 foot to the front, 10 on the side, 10 on the side. It's a very incredibly small lot, the smallest lot on the Culpeper Street. That creates this physical condition.
Okay.
And that's
Thank
what
you.
I wanted to add. Thank you.
Comments, questions, motion?
Madam Chair,
Ms. Malice.
I would like to move the staff recommendation. That is that I move the Board of Zoning Appeal adopt the attached resolution denying variance V11099-16-VA-2.
Moved by Ms. Malice, seconded by Mr. Melnick. All those in favor?
Aye.
Aye. Thank you. Next case, please.
We have another, the use permit.
-11242-17-UP-1 is a use permit request to permit a setback of 13.78 feet to the wall instead of 21 feet as required, and 13.28 feet to the eave instead of 19.5 feet as required from the rear property line. This is for a screen porch and on premises known as 804 South Quincy Street. The staff recommendation is to adopt the attached resolution granting the subject use permit with conditions.
Questions for the staff? Applicant, please.
Good evening. I don't have much more to add other than what was already submitted. We would like to have a screened-in porch for some outdoor space. There used to be a deck on the back of the house that was rotted and insufficient, and it's a better place to put it on the side of the house. Unfortunately, the subdivision, look, that picture's horrible. I have 3 little boys, which is why all of that stuff is in the backyard. But the original house from the subdivision is located behind our house, and it is set back further. I believe it's lot number 3 out of those. That's the original house. And so it creates a kind of a weird lot, and it jigs into our property a little bit. So if you have any questions.
Madam Chair, I have a question for the applicant.
Mr. Owen.
Thank you. So you were pretty diligent in getting some feedback from your neighbors to give to us, so thank you for that. But I did notice that I did not see among the signatures from your neighbors, your next door neighbor, 808, or your neighbor across the street, 820. Did you talk to those two neighbors? That's the house that's...
Because the only ones that were not on that list is the neighbor kitty corner. His Ash, and he travels a lot, and it's just very hard to catch up with him.
But I didn't see the one where the yellow vehicle is parked.
Oh, no, that is actually, I tried to put numbers onto the list, and it should have, I added them on the top of the list, so it should have been number 1.
First one I have on...
Oh, I'm sorry, this is not the updated list.
Okay.
I submitted, on the deadline, I submitted a new list. I'm sorry, there's...
So just walk us through.
Yeah.
Yeah, so my neighbor with the yellow vehicle is on the revised list. I have a copy with me. I'm happy to pass it around. It's the original.
And what about 820, which is across the street? The
street.
mirror image from your next door neighbor that we were just talking about.
On there, that's number 3 on the list that's in this packet. Wakas Ahmed.
824?
You're talking.
Yeah, 824 is directly across from facing my house.
24.
No, I mean the one next door to that. So
The one next door to that is Ash, and he just travels a lot. He has other people living in his house when he's gone. He's out of the country considerably.
Thank you.
Other questions? Thank you. No speakers?
Madam Chair?
Ms. Malice.
I'd like to move the staff recommendation that the Board of Zoning Appeals adopt the attached resolution approving use permit V11242-17-UP-1, subject to the conditions listed in the resolution.
Second.
Moved by Ms. Malice, seconded by Mr. Smith. All those in favor?
Aye.
Thank you. Thank you. Next case, please.
V-11243-17-UP-1 is a use permit request to permit a setback of 15.1 feet to the base instead of 21 feet as required, and 14.1 feet to the eave instead of 19.5 feet as required from the 34th Street North right-of-way. This is for a new screen porch and on premises known as 3367 North Dickerson Street. The staff recommendation is to adopt the attached resolution granting the use permit with conditions.
Thank you. Questions for staff?
Madam Chair.
Mr. Owen.
So the application discusses some tree screening on 34th Street that blocks the view of this proposed addition from the street. But there's currently no proposed condition language to keep that screening. And I'm wondering if staff has a view about whether or not such condition language is appropriate or enforceable, or if there's any precedent for doing that on other similar applications.
I think there is precedence. The board has in the past opted to include conditions regarding landscaping and tree screening. Staff generally doesn't offer that condition.
Okay. Thank you.
Madam Chair? Did I,
Ms. Malice.
the staff report says there's no comments. Did they come later? Have I overlooked them? Neighbor comments?
I do not believe I've gotten additional comments from them.
All right, thank you. Let's hear from the applicant. Perhaps they come bearing gifts.
Thank you for your time tonight. I'm Elizabeth Malloy.
And I'm Kevin Malloy.
We would like to put a screen-in porch on the side of the house. As we've talked about the screenage, when we moved into the home about 8 years ago, we planted trees around the property line that have grown into mature screenage. When we have had snowstorms that have taken out these trees, we have replaced them because we value the foliage and the screenage. So we intend to keep that kind of landscaping up on our property regardless of a condition. We do believe that the screened-in porch would be barely visible from 34th Street. We've spoken to all of our neighbors about the proposed porch and have had resounding support. We're happy to answer any questions you have.
Madam Chair?
Yes, Ms. Malice.
I think you should have received an instruction to bring us signed comments from your neighbors.
Well, I noticed that from the previous hearings. We did not know to do that. I'm sorry. Our builder that has helped us through the process, I came before we started and met with a zoning staff person to figure out what's a usual approved request before we began this endeavor. But somehow I missed that there was supposed to be signatures of neighbors. I apologize.
Are we, as for staff, are we handing something out now, or?
It's included in the application and the checklist. I think maybe one of the things that got missed here was the fact that the communication for their application primarily was through their, I guess it was the builder, who listed themselves as the agent and provided their email address as the only contact email address. So any additional follow-up that was sent out in preparation for this meeting was sent to that agent. And if he wasn't passing that information further along, then there could have been lack of communication there.
Mr. Owen.
So I think this is a great example of how there might be a benefit to creating a new signature requirement that actually requires the applicant to acknowledge receipt of the notice, right? And that's different from requiring them to get the signatures. That's different. That's not what I'm asking about. But I do think that this is not the first applicant we've had who has told us that they did not receive the notice, even though you guys are, I'm sure, consistently diligent in sending it out. And so being able to get something back from the applicant that says, here's our signature that we got the notice as a way of, as a premise for proceeding with the application, I think if it's lawful to do that, I think might be worth exploring.
Madam Chair?
Mr. Smith.
And to follow up on what Mr. Owen said, that, there already is a writing by the applicant authorizing the agent. They have to sign a separate piece of paper authorizing the agent to speak on their behalf with respect to the real property. So it seems like adding a statement to that would link them to that requirement to, you as a homeowner, not your agent. You as a homeowner are ultimately responsible for everything. You may give agency to this person, but that doesn't absolve you of the need to, carry out, to undertake the kind of, to develop the kind of information that's necessary for us to make the decision that we have to make, which involves.
Well, and speaking as the chair, I mean, this has come up a lot, and, don't worry about it per se. It's just not, it isn't you. It has been an ongoing issue. And in fact, I think last year as a chair, I wrote a letter that was designed to be, I thought was going to be a cover letter or in some way was going to be incorporated rather than just having it be one of many line items on a complicated application that could easily be overlooked. And I don't know where that went. I mean, I still have it. I could reproduce it. But the point being that there needs to be some way besides just the bureaucratic reams of paper and forms to fill out, that actually says, "Dear applicant, welcome to our system, and we just need you to know that we'll take your request seriously, but we also need you to know that we respect the rights and properties of all your neighbors." And so it's, much better, more beneficial to your request if you have shared your plans with your neighbors, and that at least the neighbors on either side, the most adjacent, sometimes people, just go nuts, and that's okay too, but so that we're assured that the applicant's done the outreach, the neighbors, generally speaking, in a case like this, probably would have no objection, but we can't know that unless there's something that comes to us, preferably ahead of time in our packets, because we have material a week ahead that we can review. Sometimes it comes on the evening, and it's better than nothing, but anything that comes here at the last minute, we don't really have time to read and digest. So it's a long way of saying that I still believe that there ought to be some way of emphasizing the unique issue that we're asking for, and that it becomes important so that we don't have to have a conversation like this at least once or twice at every hearing.
So I do apologize. When I asked what do I need to bring with me, he said just make sure you talk to your neighbors, and he said specifically make sure you talk to 5012 because it's the closest property that the board is going to want to know you talk to that neighbor. And so we did our due diligence and went and knocked on their door, in addition to everybody else in the neighborhood we had spoken to before coming tonight.
What's your neighbor at 5012? What is their name?
Brian and Francesca McDonald.
McDonald's. So you did talk to them.
Yes.
And
go ahead.
And what about the people across 34th Street?
Yes. Yeah, 3368.
Wait a minute,
74.
Oh, the porch is.
Oh, the
5019?
Yeah, 5019.
Yes.
Who's that?
Jeff Hayes.
Hayes, okay.
And 5025 is Beth Arthur and Joel Lovelace.
We know them.
Yeah.
And 5013?
No, they're not. They're not available in the neighborhood. They don't buy Girl Scout cookies. It's not a.
They'll open the door.
Yeah.
Okay, thanks.
That's helpful.
Yeah, thank you.
So, if I may, Madam
Sure.
Chair, I'd like to circle back to the tree screening issue. Because we don't have the neighbors, written statements, I want to be especially cautious about protecting the neighbors' interests. And so I did notice the tree screening when I visited the site, and you've mentioned it in your application. And as you heard me talking about with staff, sometimes we do put a condition in the use permit that says you promise to maintain the tree screening. Would you have any objection to including such a condition in this use permit?
No.
Not at all.
Is that something that can be done tonight?
Yeah.
Yes.
And okay. Yeah,
Yeah,
absolutely not.
absolutely.
Yeah, he would never let a tree
Yeah.
go
Yeah.
down.
Come by in the spring when it's
Blooming.
blooming. It'll be trimmed and
Yeah. Anyway, absolutely fine with us.
absolutely.
So be on the lookout. I'll read something out, and if you think there's something wrong with the way I phrased it, then just raise your hand and I'll call on you to discuss it.
Okay.
Okay, ready to move on? Are you ready with your?
Yes, Madam Chair, I'm going to do a motion and then I'm going to amend my own motion. So I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11243-17-UP-1 subject to the conditions listed in the resolution.
Second.
Moved by Mr. Owens, seconded by Ms. Malice.
And I would like to propose an amendment to add a condition number 5 to read, the applicants agree to maintain tree screening no less than the existing condition on 34th Street as depicted in the photographs presented to the Board of Zoning Appeals on March 15th, 2016.
that unanimous consent?
17, wow.
Unanimous consent?
I ask unanimous consent. So let me read it one more time. I ask unanimous consent that the applicants agree to that the new condition number 5 be added. The applicants agree to maintain tree screening no less than the existing condition on 34th Street as depicted in the photographs presented to the Board of Zoning Appeals on March 15th, 2017.
You got it. All those in favor of the motion as amended?
Aye.
Aye. Thank you. Next case, please.
V-11244 is a use permit to permit a setback of 14.6 feet to the base instead of 21 feet as required and 14.5 feet to the eave instead of 19.5 feet as required from the 9th Road North right-of-way. This is for a new porch and on premises known as 942 North Longfellow Street. I would like to just point out for the record that the subject heading on the staff report is incorrect, but the correct request was advertised and is as it is shown on the public notice.
So what are you saying?
Let's see here. This is 44, 14.6, not 15.1, and 14.5 instead of 19.5. Okay.
Okay. Any questions for the staff? Applicant, please.
Thank you. I'm Elizabeth Peterson. Thank you for your time and your service. My husband, Theodore Craig, and I have owned the home since 1996. We're very excited about the prospect of adding a front porch. We think it will add a lot to our home and also is consistent with some of the other porch additions on our block. I have talked to many neighbors, and I actually have an amended or modified list of just one thing to add. I approached Ms. Clement before the hearing to point out the error in the subject line. Just wanted to add that the first paragraph of the resolution also is incorrect. Everything else in the resolution appears to be correct, but the first paragraph refers to another property. Thank you.
Any questions? Thank you. Okay, so here's the resolution.
Yeah. Madam Chair?
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11244. I'm sorry. Yes. 11244-17-UP1, subject to the conditions that are listed in the staff report.
Changes?
Yeah, with the understanding that the staff's report in the subject area and in the resolution has the incorrect distances. However, the advertisement has the correct distances.
Madam Chair, has the motion been seconded?
Not yet.
I'll second it.
Madam Chair, I would offer an amendment by unanimous consent.
Mr. Owen?
I would offer a unanimous consent amendment that the first paragraph of the resolution specifically say, whereas the Board of Zoning Appeals, BZA, has held a duly advertised public hearing on March 15, 2017, in case number V-11244-17-UP1 for a special use permit to permit a setback of 14.6 feet to the base instead of 21 feet as required, and 14.5 feet to the eave instead of 19.5 feet as required from the 9th Road North right-of-way regarding a new front porch, R6 zoning district premises known as 942 North Longfellow Street in Dominion Hills.
No objection.
Everybody good? Okay. Moved by Mr. Smith, seconded by Ms. Freshman. As amended. All those in favor?
Aye.
Aye. Thank you. Thank you. Next case.
I would like to note for the record that V-11245-17-VA-1 was administratively withdrawn.
Thank you.
V-11246-17-UP-1 is a use permit to permit a setback of 24.9 feet to the wall from the 9th Street North right-of-way and 19.6 feet to the wall from the North Burlington Street right-of-way instead of 25 feet as required, and 17.6 feet to the eve from the North Burlington Street right-of-way instead of 21 feet as required, and to permit a setback of 15.6 feet to the base from the 9th Street North right-of-way instead of 21 feet as required, and 14.4 feet to the eve instead of 19.5 feet as required. This is for a rear addition to an existing non-conforming dwelling and a rebuilt front porch. This is in the R2-7 zoning district and on premises known as 4810 9th Street North. The staff recommendation is to adopt the attached resolution granting the use permit with conditions.
Thank you. Questions for staff? Applicant, please. Oh, sorry, Ms. Malice.
What was the purpose of the note that you highlighted on the second page at the top? The non-conforming and legal status is not.
So we recognize that there's a unique situation on this lot, whereas there are 2 dwellings on that lot. And so it just needed to be indicated that we weren't addressing the second dwelling on the lot or providing any evidence at this time of its legal or legally non-conforming status.
Okay. Applicant, please.
Board members, I'm Gene Elm, I'm the homeowner. Any questions you have, I'm ready to answer.
Okay. Questions for the applicant?
Yes.
Mr. Owen.
Who owns the house just to the south of you?
Pardon me?
Who owns the second house on this lot?
They came together on the lot, I own them both.
You own both of them, I see. Okay.
Any other questions?
Did you talk to your neighbors at 859 Burlington Street, which is on the other side of the second house on your lot?
Behind the smaller house, is that what you mean?
Yes.
I didn't speak to those neighbors, I spoke to the neighbors next to them. There are 2, if I understand correctly, 2, and it's not a duplex, they're single-family dwellings. I spoke to the person on the other side. One of the odd issues in my neighborhood is that the turnover is so high that I literally only know about 6 of my neighbors. And I don't even know them really well, but they've been in the neighborhood long enough that we speak when we see each other. But the turnover is so high that, like that particular rental property, I know the owner, but the people who are renting it now, I think, have only been there a few months. So I don't know them.
Well, I'm sorry. So that you know the owner for the property I was just describing, right?
Yeah, that's a rental property.
And have you spoken to the owner of that property about this proposed addition?
No.
Okay. What about the neighbor at 4820 across the street from you?
Yes, that's Mary. She's on the list that I am.
Yes.
I believe she's the first person on the list, actually.
Yeah, there's an address listed 4815 North 9th Street for her, which would be, oh, I'm sorry, yes, she is across the street from you. I meant across Burlington Street. So,
Same thing, that's a rental property, and there could be between 5 and 7 different people living there, but it turns over so fast that I don't actually know any of them. So if I were to propose to them what my intentions were, frankly, I don't think any of them would care because nobody seems to stay there longer than maybe a year, maybe 2 at the most.
Do you know who the owner of that property is?
I don't know the owner. The family who owned that, they were living in that property when I first lived there for maybe the first 5 years, and then they moved and it became a rental property. But I've never seen them since.
Okay. All right, thank you.
Other questions of the applicant?
Question of staff.
Question of staff.
I'm still a little hung up on this note. Previously, when we discussed granting a use permit or a variance, somehow it was the case that once we grant this, everything that's on that lot sort of becomes in conformance. I think we were talking about porches or something, the enclosed front porch, where because we were to grant that action, I think it was a variance, that on the setback, it basically brought the porch into conformance. That's not the case here. Our action on this does not have any bearing on whether this second property is in conformance or not, second building on the...
That's correct. And so that was included so anybody who reads the staff report in the future or is looking at the record of this use permit approval, that this is only applying to the main dwelling that is the subject of the request.
We can separate it, even though it's on the same parcel.
Yeah. Mm-hmm.
Because sometimes we have to tear the fire pit down because it's on the same parcel. So I just wondered why this was different. Just because we said so.
Well, this is a use permit, not a variance. Variances are more powerful instruments. So maybe if someone made the claim that we had forgiven the second house, the counterclaim would be we lacked the power to do so in a use permit.
Well, discussing it into the record helps.
Yeah, I bet it does. I have a question for staff.
Mr. Rowan.
Can this parcel be subdivided? Is that allowed? Could this someday be? So the reason I ask is that sometimes what we face is dwellings in a parcel, and a single parcel are modified and then are subsequently subdivided. And prior to the subdivision, I'm trying to think about what the neighborhood was. But we had an application about 6 months ago that was like this, where they subdivided and there was a very narrow distance between the two houses. They sold off the second house on the property. And then later, there were new owners everywhere. And or we have it on pipe stems. That's a good example, right? Someone divides into a pipe stem. And then subsequent to that, when there's further modifications that are made, people say, oh, well, my side yard is facing right into their rear yard, and it gets very difficult as a result. And so, if it's legally possible to subdivide this property, I might be more inclined to be cautious about all these encroachments, even though it's onto the same parcel, because it's a parcel that might need a greater degree of orderliness to make, for an anticipated subdivision. Is there a minimum lot size? Is there any kind of restriction that would guide us about whether or not it's possible to subdivide in this parcel in zoning?
Both lots would have to continue to meet whatever the minimum requirements are for the district.
Okay. And that's in the staff report, right? So the staff report is, there's a 10,500 square feet. It's R7, and R7 requires 5,000 square feet. So if they could squeeze around the existing lot, they might be able to make at least that requirement. Then there's also,
And it setbacks and
Yeah.
everything else. So that's,
do you have any notion about the possibility of selling off that separate house on its own lot and subdividing it? Is that something that you have thought about doing, that you've checked on with a lawyer or something that?
I've thought about it, never given it serious consideration, mainly because the way the lots are laid out, they run front to back. So the two houses are on two lots. Then the backyard, which is the side closest to the apartments or condos or whatever they are, that's two other lots. So because they're running this way, to change them running this way, I don't even know if that would be possible.
Oh, interesting. So your property already has more than one parcel, but the lot lines run the wrong direction.
Yeah, there's 4 parcels, but they run the wrong direction.
Got it.
And just the way, when the house was first built in 1920, my understanding is the little house was built to live in while they were building the big house.
Right.
And it stayed that way ever since.
That's a very informative answer. Thank you.
Okay. Ready to go?
Madam Chair,
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11246-17-UP1, subject to the conditions that are listed in the resolution.
Moved by Mr. Smith, seconded by Mr. Melnick. All those in favor?
Aye.
Thank you.
Good evening.
Next case, please.
V-11247-17-UP-1 is a use permit request to permit a setback of 3.4 feet to the wall from the left side property line instead of 8 feet as required for a new attached garage. This is on premises known as 1014 North Quintana Street, and the staff's recommendation is to adopt the resolution granting the subject use permit with conditions.
Thank you. Any questions of the staff? This is already built, correct?
It is.
Okay. So this is sort of retroactive.
Yeah, this was an error during the plan review portion of a building permit that was applied for, and the garage was approved in error.
Okay. Thank you. Other questions of staff?
Clarify, was it built by right?
The rest of the addition is by right, and that would be, I think it's a second-story addition that was on the original house, and that was by right. To enclose what was the existing carport is not by right.
There wasn't.
So in theory, because it's not by right, we could tell them to tear it off.
Was there
I'm just asking.
was there a building permit to enclose the garage?
There was a building permit applied for, and on that building permit, they included plans to do the second-story addition and to enclose the garage.
Okay.
The error was in approving the garage.
But the building permit was for a project thought to be by right at the time?
Correct.
Okay.
Mhm.
And it was, okay.
Other questions of staff? Applicant, please.
Good evening. How you guys doing? My name is Hani Nasser. I'm the owner of the house. I think she said basically everything. To sum it down, I purchased this house in June. Applied for a permit to go up the second story and enclose the carport. It was approved. I moved my family for a rental since we are attending McKinley. We went through the process. I got the email on December 21st. That would be about 10 days from me actually enclosing and getting my insulation approved. They told me it was by error. And here I am today for it. If you guys have any questions for me, I will be more than willing to answer.
So you did present us with some neighbor comments.
Yes, sir.
But you did not present us with comments from the abutting neighbor.
1010.
Can you tell us about any discussions you had with that neighbor?
Absolutely. It's a rental property. I never met the owner. I actually went to the tenant, and that's how he was informed. I gave him, I put a letter down that you guys have some signatures, and I went to present it, and he told me that since he does not own the house, he does not want to do any decisions upon the owner, and I'm sure he contacted the owner, but since they moved, so now it's the rental house next door to me is vacant.
And
1010?
yes. And what? So the two of the owners, two of the properties across the street, you also contacted.
Yes, sir.
1013 and 1009. What about 1017, the one just to your left? There's the sliver that's directly across from you, but sort of to the left.
So,
Sent a letter.
funny story, but I mean, when I first purchased the house, I was not living there, obviously, so I hardly met people, and I did not actually know her name, but that neighbor, she made it very clear that she hated the idea of tall houses. She made that clear first day while I was actually going through the plan with my builder. And she just did not give me a very warm welcome at all, and she just walked off. And since that day, I don't really think I've talked to her or she talked to me. But I can tell you this, I've been there for 3 months while I'm building this house, and every single neighbor that walked by have said, I love the house, I love what you guys have done. My next door neighbor, Miss Nancy Hall, she's been there for over 50 years. And she looked at me and she said, she smiled while she was walking by, and I was like, why the smile? And she says, I walked by that house and I had a tarp. If you guys see in the first picture, there was a tarp on the chimney. She said, there's a tarp on that chimney for years and years, and we liked the previous owner. He was a much older gentleman. He couldn't do anything. So nobody have complained about him. And she's like, I'm really happy to see it the way it is. Just, it was not intended for me to be here, but here I am, because I really did not know that what I was doing was not supposed to be done.
That's the neighbor on the corner, right, that you're talking about right now?
It's Nancy Hall, right there on the corner, yeah.
Okay, thank you.
We have a letter from Ryan Campbell, but I don't see an address on it. Am I missing it?
Ryan Campbell.
Does that name ring a bell with you, Ryan Campbell?
1017 and 1010.
1010 is, I believe, I don't know his name, but 1010 I've seen the letter, and 1017 the lady. There's another address that he's just in the other end of the street, and I've never met him, and I don't know.
Ryan Campbell, I don't see an address in this letter.
Body of the letter in the second paragraph.
The owner of 1010 North.
Oh,
Okay, so 1010. Next door.
17 also.
Yeah.
Can I show you guys these pictures real quick? I'm sorry I did not make 4 copies of them.
1010.
This is the house previous.
So that's the vacant house.
And if you can see the cardboard and how it looked, and the only thing I have done, actually, it stayed exactly in the same footprint as the cardboard. Right. So the access between me and him actually...
Sorry, if you don't mind, you can hand us the photos, but if you could go ahead and make your description at the microphone so it'll go into the record.
Sure.
Thank you.
The space between me and 1010 actually increased by me cleaning and clearing that walkway. It did not decrease it at all. And I also seen in one of the comments about the fire, even though with the county specs, they made us do a firewall on this side of the garage for that specific reason. And the water drainage, if you guys can see in the picture, actually he's uphill from me. So it's going on my yard, not his. Yeah.
Okay, any other questions for the speaker, for the applicant? Staff? No? Thank you.
Madam Chair, I mean, this is a situation where there was an error made. It wasn't made by the applicant. It was made by the county, and I'm not sure I'm willing to hold the applicant responsible for this error. So my intention is to move that we approve the use permit.
Please.
Second.
Oh,
Was that a motion?
That was my introduction.
Okay.
I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V11247-17-UP-1, subject to the conditions listed in the resolution.
Madam Chair, I'm going to second that motion. And I want to add for the record that apparently the folk at 1017 and 1010 let's see,
On a
who
different
else?
street, Potomac Street.
Yeah, there was someone on Potomac, right, 944 Potomac, that they apparently didn't have the benefit of the full record and understanding how this condition came to be, because one writes that you should not allow an applicant to do this. Well, the applicant wasn't allowed to do this. It was by the government.
Moved by Ms. Malice and seconded by Mr. Smith. Yes, Mr. Owen.
Thank you, Madam Chair. So it was referenced earlier, this article in Arlington Magazine describing the zoning appeals process. And from reading the article, as far as I could tell, the Board of Zoning Appeals was the final stage in an inexplicable process whose only function is to harass people trying to improve their historic homes. And in fact, I think we do perform an additional function, which is to protect the interests of neighboring property owners and the property values. I'm not sure that I completely agree with Mr. Smith's perfectly reasonable interpretation of the letters that we received. I think that the neighbors of these properties themselves had rights, and they had rights to notice, and they had rights to weigh in, and they should have had a right to come to a hearing before this board and make recommendations to us. Many times, in fact, on the immediate previous application, there's discussions about tree screening, or, oftentimes there'll be informal discussions with the homeowners about what color to paint something or what kind of materials to use as a way of getting support. And these neighbors have been deprived of all of those opportunities, every last one of them. And so not only are they getting a enclosed garage that is closer to their building than any other structure is in the whole street, not just the lot line, but building to building is closer, as far as I could tell, and as they assert. But they've lost all of their negotiating power to get any kind of mitigation or improvement. And I would have been inclined to defer this item until there could be further discussions with the neighbors to see if there was any mitigation that they would want to receive, since they notified us that they're concerned. I don't expect to carry the day on that, but I just thought I would put in the record that would have been my inclination.
Okay, thank you. We have a motion. All those in favor? Aye. Opposed?
No.
Thank you.
Thank you.
Next case, please.
V-11248-17-VA-1 is a variance to permit an addition exceeding 50% of the existing floor area on a non-conforming lot. This is for a new front addition in the R27 zoning district and on premises known as 844 South Irving Street. The staff recommendation is to adopt the attached resolution denying the variance request.
Questions for the staff? We hear the applicant, please.
Good evening. I'm Robin Helms, and this is my husband, Thomas Helms, and we're ready to answer your questions.
Thank you. Questions for the applicants?
I think the staff denial has to do with the justification. Could you talk about your justification for the variance?
Yes, absolutely. We live in a small house with 5 people. We love our neighborhood. We're really committed to being where we are. We are in a unique position of the house being set back much further from the street than the rest of the houses, as you can see here. We don't know why we were set back that far, but we are lucky to have that extra space. So what we've proposed will give us the space we need to be able to stay in the neighborhood, to be part of that community where we're really pretty firmly rooted at this point, and actually bringing the house in line with the rest of the street.
The standard for a variance is quite high in terms of it's not preference, it's that there's an actual hardship.
What would be a definition? One of the things that we saw, I think, that we weren't sure when we were looking at the application was what is the definition of a hardship? And
Have you looked at the staff report?
we have.
Okay.
Mr. Owen.
I don't want to interrupt Ms. Malice's line of questioning. Another one of the criteria that can apply here is, would the strict application of the terms of the zoning ordinance unreasonably restrict the utilization of the property? And as Mr. Lawson, the lawyer who was talking earlier, stated, that's a relatively new provision in the law. And so the Virginia courts haven't finished interpreting it. But I think some people think that that means, in line with everything else that the history of zoning regulation in Virginia, that probably means something having to do with the condition of the land, right? Of the structures on the land, the surrounding environment, where the water flows, where the shape of the parcel, the nature of the neighborhood, and not having to do with the particular activities of the people occupying the structure at the time, right? Because the people, the way Virginia land law often thinks of itself in policy is the people come and go, but the land and the buildings stay, right? So the question that we might want to ask ourselves in the Board of Zoning Appeals in seeking to grant your variance is, what is unreasonable about the rule that says you can't expand more than 50% of the current area? What makes that unreasonable, particular to your parcel as compared to other similarly situated parcels? Or, yes, so along those lines. That's sort of the analysis that we typically have to try and make. So I think that might be the question that we're struggling with asking you for help with.
Or put another way, Madam Chair, why wouldn't a 45% increase be acceptable?
I see. It's... Again, do you want to...
sign the speaker slip.
She's, as others have, she's our designer.
I am Wanda Madrid Diaz of WM Design, designing it. Doing the 50% would not give them the adequate space, or even, since the house is so small, the 50% rule only allows us to add on about 200 square feet to the house, up and down. That is not enough to give them another bedroom and another bathroom, which they desperately need in this house. Right now, the house is basically 2 bedrooms, 1 bath.
There's many homes like that in Arlington where people live, and so that are considered acceptable.
Yes.
So,
well, one question I have, and that is not clear to me, is whether our basement is counted as part of the square footage and whether that was taken into account in the 50%. If that was, then that would be, we'd be allowed more space.
I'm just curious, did you have a conversation with staff about the denial of their...
We had previously, we had originally proposed to have further back addition. And so we had the feedback from the staff saying, would you be willing to consider not doing the back addition? And we said, okay. And so we modified the plans and submitted revised plans. So we made one modification already at that point. The process was not clear to us. I don't know that we knew that it would be appropriate or that we should be coming after this denial, or whether it was really time to come here and this would be the time that we would be doing that.
Okay, can I just interrupt to go into the regular order that you need to turn in your speaker slip, and we can call you for testimony after we finish with the applicants, so that we don't, everything's in order and on the record. Thank you.
I mean, I think what it comes down to for us in terms of the hardship, again, we're a family of 5. We found a house that was affordable for us and where the space worked at the time when our children were smaller. We're really committed to the neighborhood. We're very embedded in the neighborhood. I teach at the yoga studio right near us. And we have signatures from all around the neighborhood of people who are really supportive of us staying there. Our alternative is to move to Fairfax or move out of the county in some place where we can afford a bigger house.
Unfortunately, that's not considered a hardship in terms of the law, that your house is too small for your family.
Mr. Smith.
Madam Chair, what is, and kind of to follow up on what Ms. Malice was saying earlier, that there are a lot of duplexes, and particularly in this neighborhood. And as you pointed out, yours is further back.
Right.
What we commonly see are these additions on the rear.
Right, where we don't have the space for that to be within the setback. So we have the option
Therein lies the problem.
that we don't have the space. So, but the 50% variance, the 50% square footage wouldn't matter if it's the back or the front, correct?
Well, when you talk about compatibility of development with your neighbors, when you see everyone else putting these on the back, they come out, sometimes they come out just a little bit and add onto the back.
Sure.
But you really don't see any on the front.
Well, that's where, again, we're set back so far.
If you were to be granted something, you would have this kind of, your neighbor would be recessed and you would be...
No, I think...
No, actually, what we're saying is that the way that Wanda has designed the plans is that by coming out the front, we actually line up with the other houses. So if you look at the houses on the...
Neighbor immediately
to the left and right, they're about... The front of our house right now lines up with the back of their houses.
That's a second case after ours that are asking for
Oh,
the
yeah,
same
we're
thing.
doing this together.
They're asking for it. Oh, they're asking for it also. Who is
Together.
that?
Yes, so
Next
they come
case.
immediately after us.
The McDougal's. Okay.
Yeah, the McDougal's are proposing the same thing.
Helpful.
Okay. So it would be bringing our whole structure in line with the streetscape.
That actually is helpful.
Okay.
The staff report does make a point on number 1 of saying 252 square feet would be a reasonable compromise. And so I think the question is going to be, it's understandable why it's in the front. It's makes even more sense when both neighbors, when both want to do it. And you know, that's probably more affordable as well. But the issues in terms of a hardship is there a reason why? I can understand why you want more space, but do we have to look at that at your personal preference as opposed to a size of an addition for both units that would not require an exemption?
What are some
It's not-
examples of a hardship, out of curiosity, that have been granted?
Topography.
Sorry?
Yeah.
Well, not with these. It has been really it really hasn't followed, because when you look at what we've done historically with these duplexes in South Arlington, they're almost all on level land. You don't have one that's high, one that's low, or back.
Right.
You don't really have any of that. What you have are these, I would say, out of time structures. They were really built for that post World War II
Right.
housing, and we're not in that era now, and so They really are moderately suitable for two people. A family, they really become extremely difficult to live in. 5 people, this is a very difficult situation. So what my hesitation was in terms of the, I was really, hadn't really gotten to the next one and didn't realize both neighbors were, that the other side was seeking the same thing. It's the unusual placement of this structure to the rear of the property is justifies some relief, it seems to me, from a strict application of the zoning ordinance. And going forward is with the neighbor. It's your only option then. But it does go back to my earlier point about the size.
If it was smaller, you would not need our approval.
Well, can I ask one question? So if our current basement, in calculating the current square footage of the house, doesn't count, but then does the basement that we've proposed does count as part of the square footage of the new proposed? So that feels...
Have something over the basement.
Yes, so what we proposed is to have a basement and then the 2 stories up in the addition. So, but if we're taking the base square footage of the house that we calculate the 50% from, does not include our existing basement, yet the proposed basement does count towards the new square footage, that feels...
Could staff explain that?
Yeah, it wasn't considered that way. So we didn't count the area of the basement as part of the existing floor area, but to that effect also, the additional basement area isn't being counted towards that as well. We're considering the above grade, the 2 floors, as the area of the addition.
Okay.
So do I correctly understand that your proposal is to bring your house into alignment with all the other houses in the row in the front?
Correct. And that's specifically the measurements that Wanda has designed for us.
And so, but you are asking later for a use permit to keep, is it to keep the same line, the existing line on the right-hand side? You're the right-hand side neighbor, right?
We're the left-hand
as
side.
you look at it,
right.
we're the left.
If you're standing in the house,
we're on the
right.
south side.
So are you expanding any further to the left? Or are you just keeping the same building line on the left side?
But we're proposing to put a means of egress in on the side. That's the, I believe that's what the use permit is for.
So to me, I feel like the unusual placement of your house, I mean, I'm satisfied that that's the unusual characteristic.
I'm not.
It's not the parcel, but we have under the new criteria, the question is, would the 50%, I mean, if the way I'm interpreting I'm not meaning to persuade you, I might be outvoted on this, right? But I think that where I've come to on this is that it would be weird, in my own mind, for the county board to have intended these rules to come out as, well, the most important thing is that you not have too much bigger of a house than you used to have. That's the most important thing. Secondary to that is bringing the neighborhood into alignment so all the houses are in a row and that your house is not the only one that's out of the row. I would be surprised if the county board a priori would say that's the order of priority. I think it seems to me more likely in line with the reasonable goals of the zoning ordinance. It's more typical to say everything should be set back, in a consistent way in this kind of neighborhood. And so I think that there is an interpretation that when the existing house is sited where it is on this property relative to all the others, when we're dealing with a condition, the only reason we're applying this 50% criteria is because we're in a historic neighborhood. That 50% criterion doesn't even come into play unless you're in this kind of neighborhood where you're trying to preserve the historic character of the neighborhood. I think it would be unreasonable to. It's not a hardship under the old law. I agree with that. But under the new law, I think it's unreasonable to say you have to push it back just because that's too big a house now.
But another way of looking at it is if they build to a line that's consistent with the other houses on the street, and there's X amount of square footage as a result of that. It becomes quite a large house. Then you look at all the other houses. Does that mean that all the other houses are going to build on the rear in order to be equally big? And is that what you want to do? It's one thing to allow an addition. We've done that in many duplexes throughout the county, which are almost always required to be pretty modest and still maintain some sort of a backyard and a rear setback, some acceptable amount. And in this case, the same should apply, I think. So
Well,
that's my issue is that what are you if this is the only one that's set back and you fill in the gap, you're allowing for all the others potentially to say, well, we want to have the same size, but because we're at the build to line, we get to go in the back, and then you have them all.
I think that's a perfectly understandable argument. I don't think it would be unreasonable for anyone to have that point of view. I think my point of view is, I would say, do you also have a 1939 structure that's unusually sited for the entire rest of the neighborhood? Because if you also do, then sure, you can have it too. But if your house doesn't start out different from the others, and you're not bringing it into street alignment that everybody else in the neighborhood can see, is out of order, then you're not, you're not starting from the same starting place.
Yeah, my guess is though that anybody who wanted to do it would come in and say,
Because it's the size of the house.
Similarly situated, now that everybody's aligned.
But nobody,
we want the back half.
And I guess my argument was, I don't know any time that I don't know any part of the zoning ordinance that encourages alignment of the rear line from house to house to house to house.
But we're talking about size.
The total size.
I appreciate
that's the only way you get it.
Exactly. And so what's the means and what's the end? And to me, the end is uniformity, and the means is a slightly bigger house here.
Madam Chair, I'm a little confused about the discussion of historic neighborhood at this point. That's not an official designation here? So we're just talking about neighborhood.
It's not an overlay.
Neighborhood character, because I look at the elevations of the proposed house, and it's obviously very different than the character of all the adjoining houses. It's got 4 peaked roofs.
I will point out that the peaked roofs, if you look at the roof lines, it also. Oh, sorry. Okay.
Anyway, so I don't know if the historic nature of it is something that we really are talking about. It's more neighborhood character.
Oh, and Madam Chair, I know Mr. Melnick wants to get in there, but I didn't describe it as historic, and I'm not going to speak for Mr. Owen, but the whole neighborhood has these substandard lots. That's really what you're dealing with, and that's why the 50% rule comes into effect. Because if they were conforming lots, then you wouldn't have this 50% rule. When we talk about size, when you talk about 300 some odd square feet more, you're really not talking. I don't think the word big should be applied anywhere in the sentence that it's envisioned. It started with a 900 some odd square foot house that's adding, in terms of floor area, 300. I know it's doubled because it's going up, but.
Mr. Melnick.
Yeah, so I'm in more agreement with you, Madam Chair, what you were saying, because when you look at what is unreasonable, if this was if the law was applied strictly, would it unreasonably restrict? And in some other cases we've had, it's what would be the modern use of this house? What's a reasonable modern use? And I think and that's sort of a nebulous definition, but I do think we can't base it on the size of your family, because then it would just you'd lose all control of the statute, and the ordinance and so forth. But so I'm in agreement with that. It's just what is a reasonable modern use of this house, and what is being proposed here, would it is it unreasonable, for instance, what the staff is recommending? And so I'm leaning toward finding that a denial, but it's just because I can see Madam Chair's argument about, well, if you went forward, then, what about the others, saying they have a hardship too, and they're moving backward. So I think it could set a bad precedent. That's what I'm thinking.
We hear from Ms. Diaz.
Is that
Could you speak into the microphone, please?
we, when we're adding on to the front, we're still adhering to the 25-foot setback. And then we're taking the house straight out, only the egress on the one side of the house. But we're not encroaching into any of the existing setbacks. And we are adhering to the 25-foot setback from the street, which all of the other houses are right now. So that just, again, it's more about the alignment, and then the adding of just the 250 square feet that the staff proposed does not work with the functionality of what they need inside the house. So therefore, since it was set back 49 feet from the street, just taking it to the 25-foot setback gives them the adequate spaces and everything to make it a more modern house. And again, it's still, we're adding 300 and something square feet to the front of the house, but it is 2 stories on a basement. The existing basement is there's no egress out of that, so we need a side egress and egress windows out of the existing basement and the new basement.
Thank you. Okay.
Sure.
Mr. Owen.
In the neighbor comments that you provided, I did not see a comment from what I think is your next door neighbor, not the other half of the duplex, but the one at 846.
Yes, it's a similar situation to the last case. He's a tenant, and we did speak to him about it, and he said, we're very supportive, be happy to do that, but I don't own the house, so I don't think I should be providing the signature.
So that's unfortunate from my perspective, because my argument that you've just heard is that anybody else except that neighbor would, walking down the street, unless they're peeking around into your backyard, after you finish, they wouldn't even know that your house lacked the same character as the other houses, right? It wouldn't be obvious that it was bigger, except to that neighbor. That's the one neighbor that would have less greenery, that would have, potentially less privacy than all the other people in the neighborhood from your addition. The neighbor on the flip side, 840, seems to have signed off on that for your abutting neighbor, but we don't have that from yours. So that makes it harder for me, to make that argument that no one's hurt. No one is hurt by this greater size. Because what I'm trying to find out suss out is, why would the county board have this restriction? What good is a restriction that says you can't add more than 50% onto your house? This is not a restriction that I think is that common throughout the zoning ordinance. It applies to some somewhat rare circumstances, generally speaking, in these duplex districts such as yours. And so I'm trying to think, well, what's that there for? Who's protected by that? And and the only thing I can think of is anyone who could see it, right, or anyone who could in their daily life, notice it, right? And because of the unusual configuration that you're offering, that you're making to my argument, you're making a smaller anomaly for the rest of the neighborhood by bringing it into alignment, but you are definitely affecting that one neighbor. And so it makes it a lot harder to say the purpose of the zoning ordinance isn't advanced by restricting you, because for all we know, the owner, and we've seen this earlier tonight, right? The tenants was like, I don't know, whatever. And then the owners come in and say, oh, no, I'm really upset by this. This is not what I could have thought I was entitled to as a neighbor.
Does the posting of the hearing and the it's public mitigate that? That they would have seen those notices if they wanted to come in?
Well, let me put it another way. I think that if we get the law wrong here, your neighbor might have the right to appeal us, right, and take you to circuit court. And so I hate to be reversed, right? But you would have a lot of trouble if that happened. And so there's some danger in us going out on a limb and approving this variance without knowing that the neighbor's copacetic.
I don't know how we would reach the neighbor. I mean, sort of in a purely practical.
Would the neighbor have been notified?
I mean, the owner. We could certainly go and get the signature from the tenants.
Often the tax records, which are public, will have a mailing address for the owner of the property.
Isn't that part of our notification process?
It is. A notice would have been sent to the owner of record for that property.
Mr. Melnick.
I had a question for the staff. Do you all have any idea of the background of this law or the intention or anything of that sort?
We can find out. I don't know the history, but it's easily researched, and we could find out and let you know. If you maybe didn't want to make a decision tonight, we could certainly look up.
I mean, I guess
acted and why and what the intent was.
From the perspective of, again, people with families that we love Arlington and we really would like to stay here, what it feels like is if it's sort of the intended use is to keep duplexes that are reasonable for a couple or, sort of a family with one child, then that's serving its purpose. But if that's what the intent is in this neighborhood is we don't want people with children and we don't want large families, then that would be serving its purpose. It's a street with kids up and down the street. I don't think that's the character of the neighborhood anymore. But that's to me, that's what de facto would be happening is we might have to move to Fairfax if this isn't, and then a couple with no children will move in. And if that's the idea is to preserve that feel of that neighborhood, if that's the intent of the law, then it will be successful. If it's not, though, I mean.
Ms. Malice.
I think, speculation on the pros and cons of this law is not appropriate here.
We don't do policy.
We're getting into policy here in terms of what is the intent, whether this law intends to screen out families. I mean, I don't think we can make that conclusion here. I have I have sort of where I'm going to go, and I don't know where the rest of the board is going. But my inclination is to deny the variance, and it can be either the applicant comes back and or doesn't come back at all, comes up with a conforming project and can skip this stage or tries to work out something else with staff. But
a deferral?
But I'm not sure, if a deferral is useful from the standpoint that if it's our sense that this should be conforming, then they maybe need us for the use permit, but not the variance. So I'm not sure how to split that out.
Madam Chair.
Mr. Smith.
Let me ask staff, the percentage over 50% is how much?
I don't have that percentage in the report, but if you give me a few moments, I can come up with it.
Okay, just a back of the envelope kind of a number. Let's see here. Let's see, I guess I could do that too. The lot is 2,742 square feet, and they want to add 3 what times 2? 382 times 2. So
64?
5128. Yeah, there it is. So it's.
I don't know if that's is that what you're looking for?
Yeah, I think so.
On this page?
That would be the lot coverage.
51.28.
Is lot.
That's a different number? Okay.
So that's the gross, looks like the gross floor.
48.
That's lot coverage. So main building, but this is all still lot coverage, right? Okay. So that's.
So the staff report says that they can go up to 1272.
additional square feet.
Yeah.
Not additional.
Yeah.
Additional?
Madam Chair, could I?
Yes,
So that-
Yes.
So that's
Total.
just the 848 square feet times 1.5? So that's the number that the staff got, because the 848 number's on the first page.
So for the 50% or the percentage that you were looking at, how far over is it? Whenever we consider the proposed additions that are after 1950, it's about 90% over the original.
You're counting that little piece on the back.
Yeah, we have to include that as well. Yeah.
They didn't do that, though. That's not their addition.
Right.
But it's a part of the structure. So you say what they're proposing would go from, would be a 90%?
Well, so we have to consider the rear addition too. That would be at about 90%. If we didn't include that area,
They're almost doubling.
almost doubling.
The 90% would be included in the addition space
Yes.
over the, so that's what's on the back is already there, though, so we wouldn't,
Yeah, you're not adding to that.
no.
But you have to count it. It has to be counted.
But that's not counted in the base, that's counted as addition space at this point.
Correct.
It's counted as if you're adding it.
Right.
Not.
Right.
I guess that is not really the number that's really not a true number to me. That's not what they're doing. I'm really wondering how much more they're doing, but that's, let's see, what is that? That dimension for that piece on the back is there, though. We can subtract that out. I think it's at, I saw it on something.
Why isn't that included?
That's 12 by, 12 and a half by 11.6. So that's another 100, a little less than 100, about 130 some square feet. So 12 by 12 would be 144, 12 by 11. So it's still a lot. It's still, yeah, that 50% is so small. With these structures, adding just 50% to them is a small area.
I think, if I'm hearing correctly, that there's not 3 votes to approve this variance. And so where we are is there going to be a deferral or an outright denial? And I'm just wondering Madam Chair, if we have a sense of whether or not, which of those is even on the table?
Yes. Or Jen?
Not encouraging, is it?
Just in terms of where the discussion is, I see at most 2 votes for approval tonight. And so I'm just wondering, since we're clearly not going to approve, are we in a denial posture, or how many people, are there any votes for deferral? And would the applicant find that in any way valuable?
I always consider deferral just as a matter of saying, would they consider a smaller addition? I understand coming out to the actual line, but there might, if they set it back a couple of feet and planted plants, nobody would know the difference. And perceptually, there's always a way to work at it. And a denial drops everything.
Yep.
And then when and if they want to start again, they have to start again with all of the applications and the fees and the this and that. So, if there isn't support for it, then I would certainly support a deferral just to encourage everybody to relook at it, but not to take it off the table entirely.
Right.
Yeah.
And reject it.
I think the key would be really working with staff to see if there's some solution that they would find acceptable. But a deferral isn't a guarantee that, it all works out in the end. It's just a time out to look at other ideas. I would support a deferral if it's understood that, it's just not a guarantee. You're going to have to do some legwork trying to figure out if there's any way you can bring this into conformance.
At least minimize it. I mean, bringing it to conformance means you don't have to come here, or at least make it smaller.
Well, they're still going to, if they're looking for the side access, they're going to,
Yeah,
they're
they
going to need
still
a
have
use
it.
permit.
They still have, yeah.
Well, and if the end of the day is, it's going to have to be, anything that's over 50% is going to be denied for the same reasons it's being denied now, which is, that's the law.
No, I don't think so.
Okay.
It's not that
and
arbitrary.
That's just not clear.
Could I ask maybe the staff a question? Do you
Sure.
know if there are, I mean, we know from walking around that we think there's some additions that exceed the 50% rule in the neighborhood. Now, they've all happened to go off the back because of the placement of the house. So, but is it the 50% per se that's hard, or is it because we're going so much over 50% by coming out to the line with the rest of the houses?
It's the 50. It's every case is different.
50% is hard because they're the staff. This is the relief valve from staff, are these 5 people right here. So I wouldn't ask them. They have to answer hard and fast. Where there were 2, there are 3 that you have to work on. Seems like to me.
And every case is different. So the ones on the back, there might be some that really push it, but there seem to be mitigating circumstances. It might be topography, it might be whatever. And in other cases, not so much. So in the end, a lot's going to depend on what you guys come up with, working with the staff, working with your neighbors and your consultant in order to try to eliminate.
I would also venture to say that, I don't want to further add to the expense of something that might be denied anyway, right? But it's possible that you might benefit from a short visit with an attorney, a land use attorney, because some of the arguments you've made tonight are not necessarily your best arguments, and there might be other ones that would be. So as you're doing your research, that might be something else to consider.
Okay. Can we move along?
Do you guys see any value in a deferral, or would it be easier emotionally just to get your,
Take your time. Have a little meeting.
Does it?
There's no one else on the agenda.
Jen is also doing kind of a similar thing, but she is moving her addition.
They're slightly different. They don't line up perfectly.
They are coming out the same in the front. So we're all kind of in this together.
I was suggesting, I'm sorry if I'm speaking out of turn, but I was suggesting that you hear our side before you make a ruling on theirs, and then
We can't do that.
No.
Unfortunately,
we can't
we're
do
not
that.
able to do that.
But that doesn't make sense.
I guess, on the deferral.
But you benefit from hearing all the discussion.
How long of a deferral do you think would be desirable to do the things that you would want to do, having heard what you've heard?
You might want to consult with this young lady back here. Yeah, the designer.
A month means you have to have something to staff in 2 weeks.
It really is tight because of advertising.
At minimum 2 months.
2 months.
Okay. We have a motion?
I would move that we defer this item for 2 months.
Second.
Moved by Mr. Owen, seconded by Mr. Smith to defer this item.
That was the variance.
Would you, read me the number, please.
V-11248-17-VA1, variance for 844 South Irving Street.
Thank you I have it right in front of me, never mind. To the May 2017 BZA, all those in favor?
Aye.
Thank you.
We have associated use permit?
I move we defer V-11248-17-UP1 to the May meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Thank you.
Aye.
You're going to do the same for the next one.
I would hear.
Did she agree?
Let's call the next case, please.
If she has a
V-11249-17-VA-1 is a variance to permit an addition exceeding 50% of the existing floor area on a non-conforming lot for a new addition in the R27 zoning district and on premises known as 842 South Irving Street. The staff recommendation is to adopt the attached resolution denying the variance request.
Okay. Thank you. Questions? Applicant?
Well, my name is Jennifer McDougall. I'm the resident and owner of 842 South Irving Street. My story, unfortunately, isn't much different than that of the Helms. My husband and I both have 3 children, all of which we've brought home to this home. We don't want to move, we don't leave the area, but you've heard this story just recently. I think after hearing a lot of these cases this evening, the real unique situation about our home, the hardship that we have, is that we have land that we feel like we can't build on. That we have a backyard that is fenced because we have dogs and small children. We have a front yard that is, for us, not very usable. It's hard for kids to kick a ball. It's hard for kids to move around and play without the ball hitting out in the street. So we decided jointly with our neighbors in our home to expand the property out and create more living space while reducing the extra space in the front. The setback, we were very careful to keep that setback at the 25 feet so that the properties were aligned in the front. And I believe that the scope of our addition that we're looking at, we planned in alignment with those setbacks, specifically in mind. And understanding that we would need a variance to build a structure that was that big, that would give us the extra bedroom or an extra bathroom that we need for our family to function a little more freely, I would say. My husband and I moved into this property 12 years ago. We were married here, and throughout our time, we have watched and we've made changes to our home to adjust to our living situation. And this, based on this lot, has always been my vision, is to move it out front. And when we decided on the setbacks and the property lines, we were really excited and we thought we had the right idea. So the size is, I think, the variance issue. I think that is it's what we need. Can we modify it? Possibly, but I think taking the neighborhood into consideration, we've looked at the design of the home and trying to make things uniform and make the house not necessarily stick out, but look renovated and updated, which I think a lot of the properties in our neighborhood need. When we first moved into our property, we spent weeks cleaning up mold and insects and replacing, but pretty much over the last 12 years, we replaced everything in the home. And so the fact that we're ready to basically dress it up a little bit and finally add that addition that we need, it's also almost a relief that we have something to put in that extra space out front of our home that we've always had. And I believe that is our hardship, is the lot. It's no bigger than anyone else's, but for some reason our house got pushed back further than all the rest of the homes on the street. So I believe that is our hardship, and that's the reason why we do want this variance. And that's all.
Thank you. Questions? Mr. Owen?
Yes. So for me, it would be really powerful if you were to return in any sort of better posture later to hear from your immediate neighbors to that yard, that front yard that would be going away, right? So the neighbors that most enjoy that as a side benefit, if we were hearing from them specifically saying that they think it would be an improvement to the neighborhood what you're doing, as opposed to on one neighbor we have a sign off and another neighbor we have no information what the homeowner thinks there, right?
Oh, I see. For the entire structure, you're saying?
Mm-hmm.
I think that
For our home and the adjoining home, the
Yes,
duplex
that's right.
itself.
That's right. Because your next door neighbor, 840, we have a signature from.
We do, yes.
Right. So that's helpful. But both of those neighbors are the ones that, even by your addition alone,
Mhm.
would be affected.
Of course, certainly.
And so, I'm just saying.
If I may add, the home, if I can do my math correctly, 848 South Irving Street was recently purchased by a realtor, modified. She went through this variance process. We visited with her when she came to have us sign a letter, and she worked specifically with their adjoining duplex owner when she added that extension onto their home before they sold it. So I do know that the house next to us has gone through at least the sign-off and variance process with the home that is in their building. And I do, I've met the former tenant was an elderly woman who had passed away. Her daughter owns the property. I'm not sure exactly where she is. I've met her when she comes into town. And personally, I can't speak for her, but I do believe that she would be supportive. I don't believe that she would have any sort of adverse reactions to it, especially seeing as how she has signed off on the same structure to have additions put on the back of her home.
And what I'm saying is that in the event that you have 2 extra months to prepare,
certainly
spending some of that time trying to track her down and getting her to weigh in could be helpful. I buy your argument.
Sure.
About the nature of the hardship and the configuration of the parcel and the 1939 structure that's already there and its existing location. I think that for me, the proper analysis of the BZA is there something unreasonable about making you follow the same rule everybody else has to follow? And so you've made your case and you've seen how that plays out. Another thing that often matters to the Board of Zoning Appeals is, do your neighbors feel hurt, or could they feel hurt? Those are similar questions, right? And so coming with your neighbors saying we're not hurt, in fact we like it more, right? That's very powerful to address that second question that we have. And a third one that you heard tonight is, if we say yes, is this the camel's nose under the tent? Is there any reason why saying yes to you doesn't mean that we're morally obligated, maybe not legally obligated, right? That's a different matter. But are we somehow obligated to think that this would be precedent set? I want to use these legal terms, but is it the camel's nose under the tent? Sure. What's so different about you that we then don't have to say yes to every other neighbor and change the whole character of the neighborhood by letting everyone be this big? So I don't expect you to answer any of those questions tonight.
Well, no, we've just recently, in our sort of gathering of signatures and in both of our documents, we gathered probably 13 neighborhood signatures supporting both of our projects, including those from right down the street who have one specific group of neighbors who'd done a duplex build together where they went up and into their backyard because they already had the setback there in the front, but they had yard in the back. So they were given the opportunity to do that in the background. So yeah, precedent does have sort of it's a motivating effect, I would say, but I don't see that as a bad thing, especially in homes that are 75 years old and in great need of repair. Most of these homes, since we've been in the neighborhood for 12 years, we've seen most of these homes go through major renovations, and most of them have additions. You can see most of them, and yeah, a lot of them are on the back, but again, I think our hardship is that we have this long, narrow front yard that it's good for mowing, but it's not good for much else. So unfortunately, we'd see it as more useful space as if it was built upon and lived in. And if you look at that structure, that 1,700 square foot structure, there are 10 people living in it. So I apologize if I speak on behalf of the Helms family myself, but there's quite a few people crammed into that small house, small structure. Building onto making an addition on both sides of the house may seem like a large project, but when you break it down into square footage, we're still looking at a home that's under, do my math, it's still going to be under 2,000 square feet.
Okay, thank you.
Thanks.
Any questions, comments? Ms. Diaz, you want to have anything to add?
About the roof line, earlier they mentioned something about concerns about the roof line. I think they didn't understand that there were dormers and things going in terms of the design.
Yeah, I guess I don't really have much to add other than what's being proposed is basically a footprint of 382 square feet on one floor, and the 50% rule is only 252 square feet. So we're only trying to add a footprint of 382 square feet into the front of the house.
Right.
That is all. And so I don't have, and then as the roof line, if you drive down the street, a lot of the houses have been pitched. The roofs have been pitched. For one reason, a flat roof is very hard to maintain. Very expensive roof to repair. So, if you have a leak, the first thing a contractor is going to tell you to do is pitch the roof. So pitching the roof just gives a nice effect. We're complying, like I said again, I want to reiterate, even with Jen, that we're having the 25-foot setback. We're having the nice 4-foot front porch so that they can all sit out there in the evenings and enjoy and just have the 25-foot that everybody else has. So we're just asking for 382 square foot footprint in the front of the house. That's all.
Thank you. Any motion?
Madam Chair,
Mr. Smith?
I'd move to defer V-11249-17-VA1 to the main meeting of the Board of Zoning Appeals.
Second.
Deferral to May, moved by Mr. Smith, seconded by Ms. Malice. All those in favor?
Aye.
Aye. And
So I'll make another motion.
please, Mr. Melnick.
Okay. So in case V1124917 UP1, I'd also make a motion to defer this case to the May 2017 BZA meeting.
Second.
Moved by Mr. Melnick, seconded by Ms. Malice. All those in favor?
Aye.
Thank you. Motion on February minutes?
Madam Chair, I move that the minutes of the February 8th, 2017 meeting be approved as presented.
Second.
Moved by Ms. Malice, seconded by Mr. Owen. All those in favor? Aye. Motion to adjourn?
Madam Chair, I move to adjourn.
Mr. Smith, seconded by Ms. Freshman. All those in favor? Aye. Thank you very much.